Okay, we're going to call the meeting to order. Monday, July 24th, Oil and Gas Commission hearing. Roll call of the commissioners.
Here. Here. Here.
Here.
I'm here. And we do have a quorum. Okay, I want to remind everybody to turn off their cell phones. Looks like we've got a pretty good crowd. This will be a civil hearing. This is a hearing. There will be no clapping, no hooting and hollering, or I will clear the room and you will come in one at a time. Everybody's going to get 3 minutes. And then after that, you can kind of summarize and everybody will get to speak, but it will be civil. Okay, approval of the minutes. Any changes to the minutes? Seeing none, motion to approve the minutes as presented.
So moved. Second.
Motion by Commissioner Boynton and second by Commissioner Hawkins. All in favor?
Aye.
Opposed? Motion carries. Report from the Executive Director's Office. He's not here, she's not here. Report from the Director.
How about this one? How about that one? That one's working. All right. Good morning. Mr. Chairman, I will keep my report very brief this morning. As you know from prior reports, the staff is actively engaged in backfilling some vacancies that were held open for budget reasons for about the past 18 months. So we do have a number of new staff on board. I will just tell you who they are and what group. So in permitting, we have a new permitting tech, Misty Mason. In the engineering group, we have a new engineering tech who actually we stole, or the engineering stole from permitting. His name is Ryan Daigle. The hearings group has been very active. Jeremy Farron, who's here, wave. Jeremy is our new enforcement supervisor. He takes the vacancy created by Peter Gowan's resignation. Stephen Ma is an enforcement officer. Stephen had been working with us as our NOAV specialist. He's moved over to enforcement officer. We'll backfill his NOAV specialist position. Jennifer Hazelton is a new hearing officer, and Stephen Kirshner is a new enforcement officer. Field Inspection Unit has added Sean O'Donnell to backfill a vacancy created by the departure of Jeff Rickert. And Mimi Larson is with us today. Stand up, wave, say hi, Mimi. Mimi is a new Assistant Attorney General at the Attorney General's office, who will be working with the commission staff on a full-time basis. I want to note for the benefit of the commissioners who are present today that we have been functioning with an acting chair for a few months now. In part, we wanted to get the commission fully appointed, to have 9 commissioners. But I just am suggesting to you that maybe you want to think about having an election for chair and vice chair. The next hearing is in Durango in September, whether you want to do it there or sometime. But at some point, we should maybe think about creating a permanent chair on a go-forward basis. That process has historically been pretty informal, but there should be some sort of nomination process and an election for.
I would like to wait until Durango.
Sure.
Because when you don't show up at meetings, they make you the chair.
Yes, look what happens. Fair enough. I just want to note that commission staff engages in quarterly meetings in different parts of the state. There are 2 different of those quarterly meetings. One is the Northwest Forum, which occurs in Rifle, Colorado. Again, pretty much a quarterly basis. I co-chair the Northwest Forum along with one of the Garfield County Commissioners. That next meeting is August 3rd at the Colorado Mountain College facility in Rifle. The second of those two quarterly meetings is called GORT, which stands for Gas and Oil Regulatory Team. That meeting occurs in Durango. That is a meeting that has been taking place for many years as a consequence of a commission order that emerged back when La Plata County was experiencing a lot of new oil and gas development, coal bed methane development. And again, these are sort of meetings of stakeholders, industry participants, the regulatory agencies, obviously, et cetera. That next GORT meeting is October 12th at the Durango Public Library. We have separate presentations scheduled for you a little bit later to update you on the Firestone, particularly the environmental mitigation response to the consequences of Firestone, and to the notice to operators that also arose from Firestone. I've asked Kyle to update you briefly on pending litigation, so I'm going to turn the floor to him now to do that. And I think that will conclude my director's report after Kyle is done.
Good morning, Commissioners. I have 4 matters to briefly go through with you. This will mostly just be a status update. And the first case I want to talk to you about is Marilex and the O'Hares versus the COGCC. That case is in the Court of Appeals. It arises out of a COGCC inspector's attempt to conduct an unscheduled inspection of Marilex wells located on the O'Hare Ranch in southwest Colorado. The issues are whether the COGCC has warrantless inspection authority and whether there was appropriate factual and legal basis for the COGCC to enter an order imposing penalties. As I said, this is in the Court of Appeals. Briefing is ongoing right now. The O'Hares and Marilex filed their opening brief on July 17th. COGCC response is due close to the end of the month. Then there will be a reply. I think you can expect the briefing won't be complete with continuance, et cetera, until mid to late September. And if there's an oral argument, we might have it by the end of the year. That's the Marilex matter. In the Martinez matter, the Court of Appeals decision was on March 32nd.
March 32nd.
Or, excuse me, March 23rd. The petition to cert for the Supreme Court was filed on May 18th. There was response and opposition June 29th and a reply by the COGCC on July 6th. So it is fully in front of the Colorado Supreme Court right now for a decision on the petition for cert. There were a number of amici briefs filed in support of both sides of this petition. It's hard to predict when the Supreme Court will decide on the petition for cert. I think general consensus is sometime in the fall. We have 2 more cases. They're much earlier on in the process than the Marilex and Martinez matters. They're both a challenge to a COGCC grant of a oil and gas surface location permit. One is the neighbors of Triple Creek v. COGCC. That has been fully briefed now. It's in front of the district courts in the first stage of litigation after a COGCC decision. We are waiting for the court to rule on some preliminary motions regarding the record and to see if the district court's interested in having oral argument on that. The last matter is the Weld Air and Water, Sierra Club, NAACP v. COGCC. That's also a challenge to COGCC decision to issue a surface location permit. We're very early on in that process. The suit was initially filed on April 12th. Opening briefing is about to start beginning of the month. Opening brief, I believe our brief will be due by the end of the month. And then we probably won't have, we'll have to wait and see what the court's going to want to do in regard to oral argument, et cetera. That covers everything. Thank you.
Mr. Chairman, I have nothing further. Happy to answer any questions from the commission.
Commissioners, questions of the director? Commissioner, comments?
Yes, Mr. Chair, I have one. There's an item on the consent agenda, which is in Group O, the Great Western matter. There were a number of protests that were filed in regard to that matter that were afterwards converted into 510 public comments. There were a number of issues that were raised in those public comments that if there are individuals here in the audience today who are commenting on those matters, I would like to be able to provide, as necessary, some additional guidance to those commenters to provide some information about the best forums in which they could raise those comments going forward. So it kind of depends on what the public comment is that we see here today, but I did just want to raise that as something I may want to speak with the director about after public comment has concluded.
Okay. Make sure you remind me.
I will, thank you.
Forgetful. When we get to the
I'll
consent.
tie something around my finger. Thank you.
Okay, we're gonna go to audience comments. If you can come up, give us your name, your address, come up to the microphone up here. What's that? Oh, yeah, we've got a timer up here for the 3 minutes. After the 3 minutes, you can kind of summarize, and then we'll move on to the next person.
Mr.
So-
Chairman, we do have a list of people here, and I plan to call them up to the microphone 3 at a time, if that is acceptable.
That's fine, and you can have them on deck and sitting down.
If they prefer to sit down instead of stand in the line, I'm fine with that also, but I think it's probably easier and quicker just to line up and go.
Okay, well, whatever they choose to do.
Okay.
Some of them may not want to stand that long. There's quite a list.
Yeah, the timer, Mr. Davenport has the timer. He'll set it for 3 minutes. At 30 seconds left, it turns yellow and it turns red when you're done. And then it's up to you if you want to allow them to continue speaking or not.
Okay.
Okay?
Okay, who's first?
We have Andrew J. O'Connor, Harry Gregory, and Tara Raphael. If I butcher your names, I apologize in advance.
But we need you up at the microphone, I guess. so
The
that we
stand-up
can get-
microphone there. if
I
you-
can't. Good morning. My name is Andrew J. O'Connor. I live in Lafayette, Colorado. I'm here to speak on behalf of myself, my family, and the people of Boulder County. So recently, the Colorado Republican legislators have acted as lackeys for the oil and gas industry by refusing to keep fracking wells at least 1,000 feet from schools and playgrounds and refusing to protect our children and our homes. Hydraulic fracking companies in Colorado release into the air, inject into the ground solutions containing known carcinogens, endangering our health, safety, and welfare. My question is, where is the outrage for the 2 people that were incinerated in Firestone? Where's the outrage? In March of 2012, Physicians for Social Responsibility called for a moratorium on fracking in order to protect human health, safety, and the environment. In June of 2015, New York State banned fracking because of threats to the environment and significant health risks. Recently, so did Maryland. My other question is, if it's good enough for the people of New York and Maryland, why isn't it good enough for the people of Colorado to ban fracking in their homes and schools? Fracking results in air, water, and soil contamination, ozone depletion, climate change, and necessitates medical treatment for skyrocketing cases of asthma, cancer, immune system diseases, cognitive deficiencies, miscarriages, and birth defects. So while the profits from fracking go to oil and drilling companies, the cost of cleanup, adverse environment, and health consequences will be borne by the people of Colorado. I've written a ballot initiative asking for a 10% severance tax on oil and gas. And I think it's high time that oil and gas pays their way in Colorado. They pay an effective severance tax of 1.5%. That is outrageous. This deadly and toxic industry is not paying their fair share, and they need to do that. My other question, I guess I'm going to end with this, is because fracking is an existential threat, if oil and gas industry puts fracking wells in our neighborhoods, threatening our lives and our children's lives, then don't we have a more responsibility to get rid of wells and thereby eliminate fracking and oil and gas workers? Thank you.
Commissioners, questions, Mr. Connor? Okay, thank you.
Mr. Chairman, Commissioners, and staff, my name is Harry Gregory. I have 3 sons and I live in Centennial, Colorado. The American Lung Association rates the Denver metro area 13th out of 220 for high ozone days. So far in July, we've had unhealthy air for seniors, children, and people with respiratory problems due to ozone pollution on the 1st, 3rd, 4th, 7th, 8th, 9th, 14th, 15th, 16th, 17th, 21st, and 23rd. That's 12 out of 23 days, or 52% of the month. Children playing outside with consistently elevated ozone have documented lower lung volumes that never improve. Ozone pollution has also shown to lead to diminished mental development in children who suffer prenatal exposure. We tend to live our lives as though the world is safe and predictable until something disrupts our plans for the future. If you've experienced a personal tragedy, such as a cancer diagnosis, you know what I'm talking about. Priorities shift instantly. Time seems to stand still. I recently watched the movie Sully. It's about the emergency landing of U.S. Airways Flight 1549 in the Hudson River. The passengers and crew share the intense emotional bond of surviving a life-threatening emergency. Captain Sully's decisions in 2 minutes gave them back their futures. Your decisions can do the same for the young people in the Martinez case. It's difficult to see the intensity of an emergency that unfolds over decades, in the same way that we see one that happens in seconds, unless we change the scale of time. In David Brower's The Earth's History in 1 Year, the history of our country has occurred in 1 second. The age of the dinosaurs lasted 2 weeks. If we continue to disregard the impacts of business as usual, human civilization will last 2 minutes. On this time scale, you have a fraction of a second to do for these young people what Sully did for the people who put their lives in his hands. I urge you to weigh the importance of your decisions the way you would in a personal emergency, because it is very personal to them. Stop the appeal, rescind all new permits, and stop issuing illegal permits. Thank you.
Commissioners, questions? Thank you.
Hello, I'm Tara Raphael. I live in Lafayette, Colorado. And I'm here to tell you that we, the people, were endowed by our Creator with certain unalienable rights. You've probably heard of this before. Among these are life, liberty, and the right to clean air and water, healthy environment and climate. However, today these rights are threatened, having been gradually usurped since our American Revolution through judicial decisions and government collusion with corporate forces. Corporations have grown in their powers, bent on profits, even at the price of violating these inalienable rights. As an agency of the state, empowered by the good people of Colorado, we demand that you do your job, protect our rights to clean air and water, healthy environment and climate from these violations, and put the health and safety of Colorado citizens above the profits of corporations. The courts have affirmed that, and now you've appealed it. Drop the appeal to the state Supreme Court. Dilly-dallying and wasting our tax dollars no longer. If you cannot fulfill the function of upholding our rights, then you deserve no public trust and should step aside and allow others to do that function.
Can we get you to hang on just a second? I think your microphone went dead.
All right, I think you heard me anyways.
Yes. We want the public to be able to hear you too.
All right, thank you. Owning mineral rights should not include the right to destroy fresh water, putting it down with fracking fluids, and poisoning the air with invisible poisons and fumes. We choose to protect Colorado from explosions and poisons that sicken and kill us, our children, and our planet, and reclaim a government that sees our fundamental rights as supreme, not as an afterthought, allowed only when they do not interfere with profits. We refuse to be colonized any longer by corporations administered by governments appointed through their money and lobbying, and have the law enforcement that we the people pay for, protecting the property rights of the few over the life, liberty, and health and happiness of the many. We demand that you, the COGCC, represent us, your constituents, from whom you receive your power to regulate the oil and gas industry, and drop all appeals against the Martinez decision. Yes, our health and safety take precedent over corporate profits. Thank you.
Thank you. Commissioners, questions? Okay.
All right, Mary Henry, Chris Lemire, and Wendy Engelman.
I didn't want to be on that list. I just signed it in.
Who are you?
Chris Lemire.
Okay, so you do not want to speak?
No. I don't sign the sheet.
Okay, then we'll call Amanda Harper up third.
Go ahead.
Hello, my name's Mary Henry. I'm from Lafayette, and I want to thank you for the opportunity to speak before you today. Last year, my husband and I had the opportunity to work on a setback ballot initiative, and I had the opportunity to meet people from across the U.S. personally impacted by fracking, people who live with contaminated water and illness, all that have been linked to fracking. Since then, I have read many studies related to the impacts. I am angered and disgusted that the state of Colorado and our legislators have allowed ourselves to be sold out for cheap, not even the highest bidder. I am saddened and mad that my children's health has been sold to these fracking industries. There is no doubt that fracking near our schools and hospitals and in our neighborhoods have a direct impact on our health. Sadly, the fracking industry is one of the most dangerous industries in the world. If we don't expect them to protect their own workers, how can we expect them to protect our families and our state of Colorado? We are the people, and we expect you to protect us. We expect you to consider the residents of Colorado. I ask for you to work to keep fracking out of our neighborhoods, far from our schools, and away from my children. Don't sell us cheap, please.
Thank you. Commissioners, questions? Okay.
Good morning. My name is Wendy Engelman. My husband and I own a property, our home in Northbrook and Thornton, and we own the mineral rights under our property. We're requesting that the Colorado Oil and Gas Conservation Commission deny the petition by Great Western, the one that Ms. Overturf referred to earlier, to drill under our home. We have always laughed at the audacity of the people who purchased homes east of us, very near DIA, and then complained about the airport noise. Surely they saw the airport, did research on flights or growth, caveat emptor, let the buyer beware. I get it. We did the research on our home in Thornton. We did not buy in Weld County. We purchased the mineral rights to our property along with our home. Please respect our decision not to live immediately next to or above a drilling operation by denying the petition of Great Western to drill under our home. The Colorado Oil and Gas Conservation Commission is charged with regulating the industry, yet for decades has relied only on self-reporting of companies to monitor underground pipes, connecting wells to tanks and other equipment in the field. Colorado does have some of the most stringent laws in the country to protect the environment and residents from oil and gas contamination. But those laws are only as valid as the enforcement behind them. After the fatal explosion in Firestone that killed Mark Martinez and Joey Irwin and left my colleague, Aaron Martinez, tragically burned, the Colorado Oil and Gas Conservation Commission released that they have only 3 employees tasked with monitoring 53,000 active wells and over 36,000 inactive wells. Inadequate doesn't even begin to describe this level of oversight. Inexcusable and negligent come closer. My husband and I have worked as teachers in Colorado for over 30 years. We are well aware of the significant and ongoing budget issues facing the state of Colorado. They impacted our ability to do our jobs daily. Nevertheless, we served our students to the best of our abilities given the resources at hand. That was our primary mission. The primary mission of Great Western Oil Company is to generate a profit. The lack of resources and therefore the regulation by the Colorado Oil and Gas Conservation Commission allows these companies to cut corners in order to achieve their primary mission. This practice results in pipeline leaks, spills, and tragedies like the one in Firestone only months ago. We are asking you to deny Great Western the right to drill under our home, and further to demand that the state of Colorado sufficiently fund regulation of the oil and gas industry in order to enforce those safety measures on the books, but not necessarily put in practice in the field. Thank you.
Thank you. Commissioners, questions? Ms. Harper.
Hello, my name is Amanda Harper, and I live in Longmont, Colorado. And on a personal note, for 2 years, I fought with every kind of possibility that I could think of against some wells being approved, 1,200 feet from the center point of the wells to my house, and lost. May 31st, they were of 2016, they were approved. It didn't matter what I did. It didn't matter what I said. It didn't matter who I appealed to. And many times I came to these commissioner meetings and I'm noticing that it's a lot of new faces. And I'm wondering who you all are as far as how do you live your life? And what kinds of decisions in a moral way do you make in your life? What kind of integrity do you have here with all these people who are human beings with lives, separate lives, coming here and asking you to do something? We're asking you to pay attention to the suffering that oil and gas industry is causing in our state. To care about the suffering that's happening in our state, beyond greed, beyond arrogance, beyond, I don't even know where the decision making comes from in this group. I can't even imagine it. It's like reading a bad novel. And I don't know what the solution is going to be. I really hope you can look inside your heart and find some compassion for all of us and some empathy for all of us today. This isn't just, people came all the way here to do this today. We're not making this up. So the Martinez case is an important case. And I don't see that the COGCC has responded appropriately. Usually, you're all about rules and regulations. That's all I ever heard. And now, oh, now there's a big one from the Supreme Court. And is that being paid attention to? Absolutely not. In fact, there's an appeal against it. And in the meantime, illegal permits are being permitted. Illegal. They're illegal because there's a whole nother way you're supposed to look at oil and gas regulation in Colorado. Not balanced, but you're supposed to prioritize and put people first. You have to prove that it's safe. You cannot do that. There's been now at least 6 years of increasing numbers of studies and tragedies that have happened that are proving that it's not safe. It's a major industrial process, does not belong anywhere near people. And then there's, of course, the planet itself that it is not safe for. So I'm asking you to void all permits since the Martinez case, since the permits did not meet the health and safety and welfare tests, which need to be principal and foremost considered rather than the balanced and last consideration rules that you guys have in place. And I'm asking you to suspend the moratorium and of all new permits until procedures are in place with full public input to ensure health, safety, and welfare is considered before any approval of new wells.
Okay,
Thank you.
Thank you. Commissioners, questions? Thank you.
Okay, next we have Martin Workline, Christy Drought, and Patricia Briones.
Hello, I'm Martin Wickline. I live in the Homestead Hills division in Thornton. And Martin Wickline. I live in the Homestead Hills division in Thornton. And Great Western is applying to drill underneath our homes. I'm here to specifically protest that. I think other people are going to do a good job of talking about health and safety and the public's concerns. But I'd like to be a little more specific. In our subdivision, I believe that the unavoidable seismic activity that's going to happen, within a few hundred feet underneath my home in particular, but we have other homes there as well, is going to cause further structural problems. So we already have some improper building and foundation work in our neighborhoods that are already causing problems, and I believe this is going to exacerbate it. But in particular, we're talking about economics here. An oil and gas company, they want to extract minerals, and we have a public interest that we're trying to serve here. Is that correct? You guys are trying to balance rights of individuals and also think about the public interest. But I'm talking specifically about economics and economic harm that is going to happen to these citizens in these neighborhoods. And the public benefit does not appear to be served in this case. You're talking about hundreds and hundreds of homeowners who are going to be almost directly over top of all of these well bore sites and the bottom holes. And you're talking about one operating company who undoubtedly has other options, other places to drill that don't include hundreds and hundreds of homes underneath. So those are my main points and why I'd like to protest. I'd like to ask that you deny their application. Thank you.
Thank you. Commissioners, questions?
Mr. Chairman,
Yes.
may I ask a clarifying question?
Sure.
Thanks, Mr. Wickmark. The seismicity that you're referring to, are you referring to the induced seismic activity of earthquakes that has been in the news, or are you referring to the seismic studies, the 3D seismic?
I'm not talking about the seismic studies. I'm talking about the induced seismic activity, including the subsequent collapse that occurs months or years after the extraction operations.
Okay, thank you.
Thank you.
Hi, my name is Shersty Drott. I live in Broomfield. I was actually planning on coming to this hearing to protest extraction, oil and gas drilling in Broomfield, and that those docket numbers actually got moved to the meeting in Durango in September, so now I changed my talking points to protest that. Durango is just so far. The company extraction is a Denver company. The drilling is happening in a Denver suburb. It's just going to be impossible for me to go there, or for anybody from Broomfield to go to Durango without really, taking days off of work and driving and all that stuff. So I would like to ask you to move those docket numbers. I have them listed if you'd like me to read them to the next hearing that will be in Denver so that we can participate there. So I'm just a regular concerned citizen. I'm not here on behalf of any entity. I agree that I think residential drilling, fracking is dangerous. I also think that this process is burdensome. To have to, follow all the regulations and submit the protest, however many days in advance and all that stuff. Make sure you have the right docket numbers. It's just hard for regular people who don't want to live next to a fracking well. So, thank you.
What were those docket numbers?
170700471. 170700470 and 170700469. So they end in 471, 470, 469.
Okay.
Thanks.
Do you have any further comments on just in case these do go forward? We understand that Durango's a long way to go.
Yeah, I mean, in general, I think it's really dangerous. I submitted a rule statement for public comment that has a lot of, studies, peer-reviewed studies. I've been to our council committees on it and have just learned that, the air quality, the dangerous potential for drinking water, especially the setbacks. The current project is slated to have only 100 feet away from a local planned reservoir, which that's like really, really close. And of course, you're not supposed to, have any accidents, or if everything goes perfectly, there will be less danger for us. But, as we have seen in fracking, there's a lot of dangerous accidents that happen. So, yeah, I mean, I'm a mom. I chose to live in Broomfield because of the good schools, because it's close for my commute to Denver. There's a lot of great things about Broomfield, and I am really not wanting more fracking wells there. So,
Okay.
Thank you.
Thank you. Commissioners, questions?
Mr. Chair,
Yes.
I'd like to ask Director Lepore to respond to the request and maybe talk in general about how we plan these hearings in order to accommodate concerns and interests in different parts of the state. I understand we go around the state precisely so that citizens all over the state can participate in the process, but this highlights a consequence of that kind of decision.
Thank you, Mr. Chair. Thank you, Commissioner. You are correct, Commissioner Boygan. There's a Colorado statute that encourages all state boards and commissions to hold at least 1/3 of their hearings outside of the Denver metro area. The commission has adhered to that policy for many years. We typically hold 3 out of our 8 or 9 annual hearings outside of the Denver metro area. We try to hold those in parts of the state that are fairly active with oil and gas. So hence Durango, La Plata County, pretty active part of the state. The applications that are referred to here are applications for spacing. They're spacing applications, not drilling permits, not location permits, fairly technical issues. I'm fairly sure, I know there are some extraction representatives here and they may want to say something, or particularly if I don't get my facts all correct here, but extraction had expressed an intention to file their spacing applications a month earlier, so they actually would have been heard here today. There's an ongoing oil and gas committee in Broomfield. I'm sure all the Broomfield speakers are aware of it. And that committee, and my understanding is the city council asked extraction to delay filing those spacing applications for 1 hearing cycle so that the oil and gas committee could continue its work, and extraction agreed to that. Turns out that hearing is in Durango. So I received emails from about a dozen Broomfield citizens in advance of this hearing, expressing the difficulties of the logistics of getting down to Durango, expressing their desire to be heard. And my response to those folks was, we have a hearing on today in Denver, and they are welcome to come and comment there. But of course, if we hold all of our hearings in Denver, it's not convenient for the citizens in other parts of the state and all of that. So,
if I might follow up, Mr. Chair.
Go ahead.
So what I'm hearing is that this is a preliminary stage. It's spacing. There's a lot more to come. There will be many opportunities to comment, to have input in the process as this unfolds. And so whether or not people can comment, can make the trip to Durango in September won't be determinative, conclusive, won't end the process.
Well, it almost sounds like you guys have made up your mind then to move forward with the spacing applications?
No, there's been no vote.
Okay. I mean, because it sounds like, well, it's just the beginning of the process. There'll be multiple other applications and, we're not quite drilling yet. But it's like, well, I mean, I don't even want the beginning of the process to start. That's why I'm here.
Okay, well, your comments will be taken forward when the commission considers those applications in Durango next month, so.
I'm sorry, Mr. Chair, may I make a
Go
brief
ahead.
comment? I do want to say that I'm sensitive to the time limitations that extraction may be under. However, I do hope that extraction is taking a real look at whether it can accommodate a 1-month delay and voluntarily hold this matter over until the next hearing that's going to be in the Denver metro area. So hopefully someone from extraction is looking at that in order to respond to the concerns from the community that are being voiced here today.
Mr. Lepore.
Thank you, Mr. Chairman. I would also add that the protest date for the hearing in Durango is late August. I don't know, one of my hearing staff can look it up for me, 28th of August or something like that. So if there is a protest to those spacing applications, that often results in a delay. It's not required, it's not guaranteed. But I think extraction has to consider that fact as well, that this may get continued, whether they do so voluntarily or not. That's just another part of the puzzle of how these hearings come together.
Okay. You might want to consider the task force that Broomfield's put together and go in front of them and have them maybe request from extraction to continue this until the following meeting, I don't know, in October.
All right.
Instead of Durango. That might be another avenue for you.
Okay. Thanks for the suggestion.
You bet. Thank you.
I think I need a different microphone. Can you hear me?
Yes.
Oh, that's nice. Thank you. Thank you very much. My name is Patty Briones. I live in Centennial, Colorado. I belong to Food and Water Watch, and they asked me to come in support of the youth plaintiffs, the Boulder Water Keepers. I believe that's part of the Martinez case that you mentioned, and I am supporting them. I do support them. But beyond that, one would think that we all would have as our first priority clean air, clean water, safety, and health for our children. That does not seem to be the case in all instances. I would ask the commission as individuals, I appeal to you as individuals and as a commission to have as your first priority the health and safety of our children and our grandchildren and future generations. As a grandmother and as a concerned citizen, have that as your first priority. Thank you very much.
Thank you.
Okay, next up we have Mark Gormley, Cheryl Olson, and Larry Moore, MD.
Hello. Okay, I'm also here as one of the Homestead Hills
Can you give
homeowners.
us your name and your address?
I'm getting to that. I live at, my name is Mark Gormley. I live at 13650 Claremont Court in Homestead Hills, one of the 4 affected communities that is being approached by Great Western Oil and Gas for drilling. I've written something that I will read, so hopefully I can just get through that quickly, and if there are any questions, I'll entertain them. I will make one statement though, as far as spacing, pooling, drilling, or whatever, it's all part of the same game. We're at the early stage right now of spacing, and we don't want to see anything progress from this point forward. Okay, so I could present to you a multitude of professional research findings and scientific reports, but given the required brevity for this appearance, 3 minutes, I will go with what I have found to be quite evident through my own analysis. Most of us, including myself, do not want to be here. You can hear the shakiness in my voice. I don't want to do this, but I feel compelled to do it. We feel compelled to be here. Many of us are justifiably angry at the greed and selfishness of the oil and gas industry that drive us to be here. Had the United States implemented and followed the last written energy policy 40 years ago, we wouldn't need to be here. Okay. We obviously cannot get rid of fossil fuels immediately or all at once, but this stalling tactic of saying that renewables are no good has been employed ever since Jimmy Carter was surreptitiously removed from the White House by the blatant purchase of Ronald Reagan by the oil and gas industry. Reagan sold out the country's renewable energy future and worldwide prominence in the production of renewables. We've been heading in the wrong direction ever since. And now the oil and gas industry is emboldened by the current Washington administration to get away with turning back the only protections we have from the EPA, even brushing aside all the detrimental health and environmental impacts. This wrong-headedness needs to stop now. We need to move forward with renewable energy, which has proven its value and long-term sustainability. Why do we need to contribute to the stall on progress in moving to a new energy economy? And I barely have the time that I need for even this. I will try to get to the gist of this, but and I'll leave what I've written for you to publish, do whatever you want with. But this is all kabuki theater. The COGCC just approves everything the oil and gas industry wants. I've got 2 daughters. I've got a home up in Thornton. I own my oil and mineral rights. Thank God I have at least one tidbit to fight for. But the forced pooling is just going to wipe that all away with your consent. And this is wrong. We need to get off fossil fuels and move to renewable energy.
Okay, thank you. Commissioners.
I would just say that if you do have a copy of the written comments
The
that you
hearings
would
officer.
provide, that way we'll all get a copy. Thank you very much.
morning. My name is Dr. Larry Moore. I'm an emergency medicine physician. I have lived and worked in El Paso County for the last 39 years, and I'm here representing myself, my children and my grandchildren, the patients I've cared for over the last 39 years, and the residents of the state of Colorado who are in dire need of assistance here. I have 5 statements I want to make that I believe to be truthful and I want to emphasize. Number 1, the Court of Appeals decided Martinez 4 months ago, and the effect of that decision was immediate and imposed clear duties on the commission. Merely your petitioning for cert does not change that fact, and there's been no stay of judgment. Currently, what is being done is status quo and needs to change based on the Court of Appeals decision. Number 2, the Court of Appeals very clearly determined that the Commission's statutory mandate is to ensure the protection of the public health, safety, and welfare, including the environment, and before any oil and gas development may be permitted. Number 3, the Commission's current practices and regulations under which fracking and other oil and gas development continues to be routinely and consistently permitted are inconsistent with the agent's statutory duty to only allow oil and gas development when it's consistent with the protection of public health, safety, and welfare, and including the environment. You've got it backwards. Number 4, the Court of Appeals decision requires the Commission to reconsider the youth plaintiff's petition for a rule that protects their statutory, constitutional, and public trust rights for themselves and for future generations of Colorado residents in line with the emissions reduction necessary to avert catastrophic climate change. Number 5, in light of the Commission's recently recognized and reaffirmed statutory duty to protect the public health and welfare before authorizing any development, and in light of the inconsistency of the agency's current regulations and actions with those duties, the Commission is legally obligated to begin promulgation of a rule consistent with and by which it can fulfill these well-defined duties, as clarified by the Court of Appeals. The Commission should begin that process now and provide the public with a schedule for that process now, delineating opportunities for public participation. And I ask that of all residents of the state of Colorado. Finally, how many of you have children? How many of you have grandchildren? I see that our mission together is to protect our precious water resources, decrease carbon dioxide and methane emissions, and provide a sustainable and healthy environment for our children, our grandchildren, and future generations. This starts now in Colorado with abiding by the mandates set forth by the Court of Appeals. How can we not choose clean air and water for our children? And how will you answer when your children and your grandchildren stand up and say, Grandpa and Grandma, what did you do to help our state and our earth? Thank you.
Thank you. Commissioners, questions? Please be respectful of the 3 minutes. We've got a lot of people to go through.
Thank you. I'll only take a minute and a half since you guys also graciously allowed Dr. Moore to complete his statements. And I certainly concur with everybody that has been speaking here. My name is Cheryl Olson. I'm also from Manitou Springs here in Colorado. And I really want to thank you for giving us each the opportunity to speak in front of you today. I have handouts, and I'll pass them around, of the 5 points of the required law set forth by the decision of the court. I only have 6 copies. I apologize for that.
Hearings officer?
So I thought you could pass them around, or what?
Just give it to the hearings officer, and then
Okay.
you'll give it to us, or the AG.
Okay, I'll do that. My interest in this and my reason for being here is because I am an educator. I am an educator of wilderness medicine. I travel all over the world educating people on how to take care of people that have medical health injuries. Every year in Santa Fe, we have a global health and humanitarian workshop that I speak at in front of about 500 people in Santa Fe. And I speak on the effects of climate change and global health. And I think we all really do need to think about what climate change is doing to the health of our children. Dr. Moore asked you, how many of you have children? How many of you do? Are you okay to answer that question? Are you allowed? You can answer that question in your heart. And how many of you have grandchildren or perhaps will have other grandchildren? This isn't for each one of us sitting here in the room today. This is for those of us who have a passion about air, have a passion about water. Air is life. And as our Native American Indians say, Mini Wakoni, water is life. Water is also life. So thank you. Hope that was only a minute and a half.
Thank you.
Next, we have Catherine Thomason, MD, Lauren Swain, and Elizabeth Huditz.
Hello, my name's Dr. Catherine Thomason. I'm recently retired Executive Director of Physicians for Social Responsibility. I first wanted to thank you for your wonderful staff who answered many of my questions as I'm new to Colorado about the website and the work that is being done. And a lot of work is being done, but unfortunately it's not enough. So have you struggled with nosebleeds? Have you had dizziness, lightheadedness, wheezing, or fatigue? If not, then you may not live next to a wellhead or a condensing station or a compressor station. These areas have fugitive emissions of volatile organic compounds, including methane, benzene, toluene, xylene, and other volatile organic compounds, some of which are neurotoxins and carcinogens. The study of air toxics done by the Public Health Department here indicates that those are being released. I have taken care of adults who were born with congenital heart defects. Some have had major open heart surgery. Others live under the threat of a shortened lifespan, worry about arrhythmias or sudden death. Birth defects were clearly statistically linked to the density of wells around which women who were pregnant lived. Increased rates of childhood leukemia were also statistically significant the closer they lived to a wellhead. These are not diagnoses to dismiss. The fetus is the most vulnerable period of human development to toxins in the air and the water that are released from air and water, oil and gas drilling. Setbacks of 500 feet are completely inadequate. If you do not protect the fetus and children, you are not protecting all public health. So I want to quote in the air toxic study that was done, and I'm very sorry that Mr. Wolk is not here today. This is a quote from the air toxic study that was done by the Colorado Department of Public Health. It says, long-term exposures with all substances combined were slightly elevated above safe levels. And again, I still quote, however, this is a very minor finding, considering the large number of substances evaluated, unquote. Well, it's not a minor finding because all those substances get breathed in, get deposited in the soil, and get taken in by children by eating. So what they found is that 3 of the areas were higher than they should be. And when you get more and more density of wells, you get more and more air toxics. The rest of the combined was in the quote unquote safe area. None were in the negligible area. So again, as you increase in density, you're going to find that we're going to have more people who are ill. So just to summarize, the commission, to do its duty to protect public health, the other thing it really needs to do is to look at the things that you are not currently being able to regulate. I think it's a shame and outrageous that Chevron can do a spill and argue with you that you are not allowed to regulate that spill because it was in a line that you do not have control over. Something wrong with that. Thank you.
Thank you. Commissioners, questions? Okay.
Hi, I'm Lauren Swain. I live at 3277 Raleigh Street in Denver, Colorado. I breathe, and I'm breathing air toxins from wells in Weld County and neighboring counties. And people living closer to those wells are breathing more air toxins and are at greater risk. Proximity is the biggest factor in risk of the unacceptable risk being posed to thousands of Colorado residents from spills, fires, explosions, toxic emissions, water contamination, decreased home values, and many other threats that we know accompany residential drilling. Residential drilling is an unacceptable violation of human rights, and it needs to be stopped now. The 500-foot setback, as was said previously, is entirely inadequate, and there are studies to document that effect, including by environmental health perspectives. I recommend that you read that evaluation of state setbacks. They are completely inadequate, and this is a violation of our human rights in Colorado. Further violations of our human rights in Colorado are grossly elevated benzene levels and ozone precursors that are putting 9 metro counties out of compliance with our federal laws that are intended to protect our health and safety. And by the way, all of these operations are being performed outside of the federal laws we depend on for our health and safety, because the oil and gas industry has driven holes into 7 major environmental laws that we depend on, including the Clean Air Act, the Clean Water Act, the Safe Drinking Water Act, RCRA, CERCLA, and NEPA, and the Community Right to Know Act. They do not have to comply with the letter of the federal law, and that is why they are allowed to do what they do. And it is completely unacceptable for this commission to permit well after well in community after community where people are fighting and their city council members say they can do nothing because they are routinely threatened by this industry. This is an abomination. And now to have this commission appeal a decision that our health and safety must come first, it's an abomination. It is wrong, it is harmful, it is disgusting. And everyone, I encourage everyone in Colorado to stand up and stop this menace with every means, every nonviolent means that they have to do so. And they should, to protect others, not for just themselves, but for others and future generations, because this pollution is going to be a menace to our communities for a long, long time. That was a non-used well with non-used flow lines that blew up in those people's faces and killed people in Firestone. And we don't know when it's going to happen next, but we do know that it will happen. Stop it.
I'm gonna have to raise this.
Hi, my name is Elizabeth Huditz. I'm from Fort Collins, 80525. We are all connected. We all breathe the same air, drink the same water, essentially, live on the same planet. We are what is currently called the 6th extinction. More than half of the life as we know it on this planet has disappeared since the Industrial Revolution, and it's related to us. And yes, it's more than oil and gas, but that has a huge impact, and it is exacerbating what's already been happening. State lawmakers charged the COGCC with fostering responsible, balanced development, production, and use of oil and gas in a manner consistent with protection of public health, safety, and welfare, including protection of the environment and wildlife resources. For more than a decade, COGCC officials have interpreted this to mean balancing oil and gas industry interest against public health, safety, and welfare. It's my understanding that no permit has ever been denied. I would ask if that's true? And if it's not true, what percentage of the wells applied for have been denied? I'm very curious about that. I'm also here to address the Martinez case. They proposed that Colorado not issue any new permits for oil and gas drilling unless the best available science demonstrates and an independent third-party organization confirms that drilling can occur in a manner that does not cumulatively with other actions impair Colorado's atmosphere, water, wildlife, and land resources, does not adversely impact human health, and does not contribute to climate change. And I think we all know that that can't be done, which is why we're all here, because 2 out of 3 of the people were wise enough to agree with that, and yet the fact that it's now law doesn't seem to stop this supposedly law-abiding group of people who are charged with making sure things are safe. That bothers me, and I think it bothers a lot of people. I've never really understood why the oil and gas industry doesn't just switch gears and back alternative energy and become the good guys instead of being thought of as predators destroying life as we know it on our planet. And I would also like to share with you an image I have of us in an automobile heading towards a cliff, stepping on the gas. And I think that's a pretty good analogy. So I would just say, please wake up. We're killing ourselves. We're killing everyone. And I don't know if that doesn't bother you, or if I know you got to make a living. We all do, but we also would like to live with making the living. So thank you for your time, and please think about what you're doing and do wake up. And again, I know you have to make a living, but why don't you just switch gears, you know? Alternative energy.
Next up, we have Vivian Weinstein, Georgia Locker, and Kathy Riley.
Can I just ask if there was an answer to the question of how many wells have been, how many permits?
You need to direct that question to Mr. Lepore. You can just call the staff and they can get that information for you.
So we don't know. So,
Yeah. No, we do.
Thank you.
Okay. My name is Vivian Weinstein. I'm an out-of-state agitator. I'm a 75-year-old agitator. I have grandchildren and children. I came here from Maryland 3.5 years ago, so I'm not out of state anymore. Okay, I came here to the Wild West and kind of thought it was a dangerous place, maybe, you know. I took a ride from Fort Collins down to Denver on Route 25, excuse me. I am learning. 25, and my friend, who is very familiar because her family has wells on her property or something, they drilled there, was pointing out what the wells look like. I mean, I know the big, tall drilling thing, but I didn't know all these other storage tanks and stuff. And I sort of estimated, and this is not scientific, about every quarter mile, there was another site. This is just along the highway, both sides, about every quarter mile, 60 miles. It's quite a few wells. A lot of them, you know, estimate maybe, luckily, 200 feet from a structure. Very unlikely. Most of them are closer than that. Obviously, I didn't go out and take a tape measure. We're doing 60 miles an hour. I was really impressed with the Colorado fracking operation. It's going on for a long time, since the 70s, I understand. But in the new method of fracking, which is the one that's most problematic today, where they can go under the properties for miles and miles, actually up to 5 miles. I don't think they do that much here. Down 5 miles and out 5 miles per some drillers that I spoke to. They can go under a lot of properties. Okay. We don't know where the pipelines are. We don't know. We know the health effects. We've talked about them today. We've had an explosion which destroys life, with the potential to do more because there's really no oversight. And I read about how they do oversight in this state, and there really isn't much of it. Okay. And so the potential for more explosions and lives lost is there. The fact that it's the most, not one of the most, but the most dangerous industry to the workers because of the chemicals, the sand, the just the type of work that it is, you know, and the things that they're working with. We don't know all the chemicals that are used because we're not allowed to know that by law for fracking. So I thought, okay, you know, I'm going to not get myself knowledgeable about this topic. You know, I'm going to do some things for myself. I'm going to work on this. So I threw out all my Teflon pots. I threw out all my plastic dishes, replaced them with glass. I got all my household cleaners out. I just tried to detoxify my environment. You know, I use a steam mop, no chemicals on my plastic floor. I'm even a vegetarian. I don't even eat meat, so I help the, you know, environment that way, you know. Try to eat organic food when I can afford it. I filter my water. I don't eat tuna fish to avoid the mercury. We could all do this. It would probably work, you know, have a pretty good effect, I think, but it's not enough, you know. A lot of these products are made by petroleum products, and they themselves are a danger to our lives, and it's not talked about enough.
Ms. Weinstein, can you go ahead and summarize, please?
Pardon?
Can you summarize?
Not really. I could go on for a long time.
I know you could.
But, you know, when I came here, the first thing I read in the paper was the methane over Weld County. And then I heard about Harvard doing a satellite study with the whole Earth, with the amount of methane that has massively increased in the last few years. So a lot of the people they've talked about the health effects. But I just want to tell you this is ridiculous, okay? This has got to stop. We've got to stop the permits. We've got to look at the health of the people of Colorado and appealing a decision that's regarding the health and safety of the people that live here, not the profits, not just the profits and the money. And I know that's important to you. And maybe not so important to me because I'm getting very old and I can't take it with me, okay? But, you know, you guys, you got to really think about this. You've got to stop this appeal. That's really foolish. Really, 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 really foolish.
Okay, thank you.
My name is Georgia Locker. I'm from Fort Collins. I have a quote from your charge. Quote, "The Colorado Oil and Gas Conservation Commission is charged with fostering the responsible development of Colorado's oil and gas natural resources in a manner consistent with the protection of public health, safety, and welfare, including the environment and wildlife resources," end quote. A NOAA study in 2016 has shown that 17% of the methane emissions in the Front Range come from the drilling for fossil fuels and its transportation. This is a contributor to the 80 parts per billion or more readings that we regularly see on the Front Range, putting Colorado out of compliance with federal standards of 70 parts per billion, which were supposed to be achieved prior to this year. Governor Hickenlooper this year agreed that Colorado will make a commitment to the Paris Agreement, along with most of the nations in the world. This means we need to reduce our greenhouse gas emissions by 26 to 28% below the 2015 levels by 2025. We can only make this happen by working alongside the nations of the world. We must reduce our air pollution in Colorado starting now. I ask you to support the ruling by the appeals court judges that the COGCC must relegate oil and gas development. State lawmakers have charged the COGCC with fostering responsible, balanced development production in a manner consistent with the protection of public health, safety, and welfare. I also am sorry that you are appealing the case brought to you by the Martinez group. I believe it is in the best interest of the citizens of Colorado and the country that you do not approve future requests for drilling until each request is looked at for its location, who will it affect, what it will do to the land and water, and what it will do to public health. At this time, according to the May 2017 Denver Post article, we already have approximately 55,000 active wells that appear to produce more than what we need in the U.S. When the drilling started, we were told that it was to make us independent of other countries, but most of the product appears to be for export at this time. The Post states we also have 6,000 approved permits to drill, and there are at least 15,000 abandoned wells on the books that have not been capped as per the Denver Post. We need the Colorado inspectors to get that job done before we add more wells, in my opinion, and we are woefully short of inspectors in this state. Earthworks has stated that an inspector can only do 900 or so wells a year, and each well should be inspected at least once a year. The article also states that each new well must be inspected 3 times from drilling to completion, and that would mean we need to have at least 60 inspectors in this state to do your job. Thank you.
Thank you. Commissioners, questions? Okay.
Good morning. My name is Kathy Riley. I live in Denver, Colorado, and I'm here with Food and Water Watch, my first time to join them. I'd like to thank you for this opportunity to speak today, and I would especially like to deeply thank every previous speaker who has educated me and inspired me to continue fighting for health and safety. I am fortunate to live in senior housing in probably the prettiest part of Denver, right by City Park. And I walk there every day, breathing the beautiful air. And I look at the pictures of those 19th century guys who thought having natural resources and public parks were really, really important. And I honor their legacy. I turned 70 this year, and as they say, and have found it to be so true, that it's not the things you've done that you regret, but the things that perhaps you haven't done, the opportunities you didn't take. I urge you to please consider that. You have a great power and you have great knowledge. And please remember Mr. Scudder, the 19th century guys who left us City Park. You can do the same. Thank you.
Thank you. Commissioners. Okay, who's up?
We have Marion Butterfield, Patty McClellan, and Barbara Mills Bria.
I wasn't called first, but anyway, my name is Patty McClellan Connolly. I live in Denver, Colorado. I came in here and anything I wanted to say just went off the top of my head. I have no idea because this is such insanity to me. It's kind of like the world out there right now. I have no idea what is this insanity of what's going on. I was here 2 or 3 years ago with a young 14-year-old Mr. Martinez sitting there doing a PowerPoint presentation for you guys. And in it, he was explaining what was happening to our planet and our children because of fossil fuels. And at the end of the speech, I remember I said, I hope every one of you go home tonight, and if you wake up at 2 in the morning, you have this young man's face in your brain. Because this is yours. I too salute what you do. I imagine all of you are at least high school educated. I'm sure you know about science, and you do know the danger of what's going on now for our planet. Specifically, fracking and methane in Colorado is warming our earth like nothing else. I come from the addiction field, and I have to say that when they talk about opioid or alcohol addiction, one quote I loved was, we are obsessed with a compulsion that seems to decree that we must go on with our self-destruction. I believe we are addicted to fossil fuels, and I think we are racing towards that wall like someone else mentioned. And it is, you guys are here because we want you here. And I know you have children like we do. So I'm just saying, I've seen a lot of powerful, especially women in this room today. I think you're in trouble. I think we're going to win this, and I think you know that in your hearts because it's wrong. One other thing, just something I saw from something I went to. It's pretty simple, just a visual of if I have the earth in one hand and gold and money in the other, which one are you going to choose? That's simple. Thank you all.
Thank you.
Yeah, my name is Barbara Millsbury. I'm representing Be the Change, and I live in Lakewood, Colorado. And I just wanted to say, we've been trying to get this through to you guys for years. And at first we were told, well, there aren't enough studies, that we don't have enough studies. Now we have enough studies. And we used to be worried about asthma and cancers and breathing issues and ruining our water. Now we're also worried about our houses blowing up. And you know, the developers are building in the gas fields because everywhere is a gas field. And I just wanted, Mr. Lepore, you mentioned, I mean, you made it sound like extraction oil and gas was delaying because they're concerned about the people. But you know, they're publicly traded company in their junk status now because they're not making any money. Yet, each of them got $26 million in a salary, according to the Denver Post. So this is all about money. We do not have money. We are here because all we have left is our voice. And you guys can expect to hear us and hear our voices in the future because this is all we have left. Anadarko and Noble funded 94% of the effort to pass Amendment 71, which took away our direct democracy. They couldn't even satisfy their own rules. And I was really offended. I know you want to keep us all to 3 minutes and you're afraid we're going to be rabble-rousers. Get us. We're just human beings. We're just people. And I know, Mr. Holton, that you work for the oil and gas industry, so I imagine.
I don't.
I thought you did.
I'm a farmer. I never have.
I thought you were a welder for oil and gas.
No, I've never.
Oh, well,
worked
you
for
need
oil
to
and gas.
correct that on the Fort Lupton website, because that's what it says. Sorry.
That's news to me. I wished I had because I'd have some of that money, but I don't. I'm a farmer.
Well,
I'm still waiting
in
for
any
rain.
case, I know that the millions of dollars that they have is very impressive. They wear nice suits, et cetera, et cetera. But you know what? They're wrong. And we're right. And we pay you guys. And we would like to not have our taxpayer money used to appeal the Martinez decision. So we'd like you to just drop that appeal. Thank you.
Thank you.
Is Miriam Butterfield here? All right, we have Michaela Nuka Steiner, Phil Doe, and Rick Creswell.
Hello, my name is Michaela. I live in Boulder, and I am a U.S. Youth Delegate at this year's Conference of the Parties, or the 23rd UN Climate Talks. I'm going as a representative of U.S. youth because Rex Tillerson doesn't represent my generation and doesn't represent the people of this country. And I think that if you do not stop the appeal of the Martinez case, you will not be representing your constituents, which includes young people, which includes workers in the oil and gas industry who are put at risk every single day to provide energy for people because there is no good oversight. And I'm really furious because you have been neglecting your job for years. And you know it. So I have two questions for you. Whose side are you on? The people of Colorado or the oil and gas executives and the industry? And do you stand for fracking or do you stand for clean, renewable energy jobs that are safe, that employ millions of people? What do you want? And what are you going to choose? So stop the appeal, stop your BS, and get to work. Thanks.
Okay, who's next?
I'm Rick Creswell, and I'm from Lakewood, Colorado. My address too, 2557 South Dover Street, 80227-3161. I'm here to ask for a little reflection. I understand that dual mandate of the commission is conflicting. There really isn't any way to encourage oil and gas drilling, and at the same time, protect citizens. But we're reaching a new point in time. If you look at oilprice.com, some of you may, the editors of that keep wishing that Aramco would stop producing oil for a while or cut back. Keep hoping somehow it'll cut back so the prices can come up. The prices, as everybody knows, are stuck. So why are we ripping through things so desperate we have to go under people who are not two-shirt people, by the way, just the one-shirt folks? My mom had that expression. If you had a little more, you were a two-shirt person. It comes under the one-shirt people. Why are we so desperate to get under them so that maybe we can keep a zombie company going that just can only produce enough income to pay off debts? Or we have the largest oil company in the United States that doesn't make enough money to pay its stockholders, so it borrows money in the low interest rate environment to pay its stockholders. Something in there is missing, and that it's time to see that even the money, it looks like a rush to be the last person producing assets, not to have one standing in the ground. It's time to stop and think that now is a good time to go to the other end of the mandate to protect people rather than oil and gas companies. They're not making money now. And it doesn't look good for the future. The next day doesn't look good either. You hear the hoofbeats of renewable energy and you can hear the slurping of the straw. And I don't think Colorado wants to be the last place pumping gas and oil. Thank you.
Thank you.
My name is Phil Doe. I'm the environmental director for Be the Change, and like Tom Payne, I consider myself a citizen of the world. I'd just like to add to what Barb said about Extraction's financial situation. Moody's gave them a rating of B3 the other day. The Wall Street Journal, probably established corporatist newspaper in the United States, recently came out and said the fracking industry is on its knees, soon to expire. Now, I'd like to tell you about what I came here to talk about. Right after the Firestone fire, we wrote a letter to the governor asking him, in all sincerity, to appoint an independent commission to examine what happened at Firestone. We did this because normally people that cause accidents aren't given the freedom to determine how responsible they are and how to correct that accident. But that's what we're asked to believe in this state. We as citizens have to sit on the sideline and listen to this garbage. We gave him a list of grievances that we thought that this was basically a cover-up because it only covered 19,000 of the 50,000 operating wells in the state. And if you look closer, for all of Anadarko's abundance of concern, or whatever the hell they called it, almost all of their wells were stripper wells. It accounted only for 3 to 5% of their production. So they're going to examine 19,000 wells. 31,000 wells are not going to be examined. 58,000 non-producing wells are going to be outside the investigation. All pipelines are outside the investigation. We have 45,000 miles of trunk lines in this state, and only the interstate lines are under anybody's purview. And that's the Department of Transportation. It's a tiny little organization. The rest of it is no man's land. We have no idea what the public health threats and safety are on all these lines. Neither do we have any idea what goes on at the compressor stations, how much leakage is there. I mean, this is, you've got Bob Howarth at Cornell thinks the leak rate on oil and gas is 12% if you look at from upstream to downstream. 12%. That's a tremendous threat to the climate. We wrote a second letter to the governor. We heard nothing. We wrote a third letter to the governor. Now, this man did not have the dignity to respond. There were 16 people that signed the third letter. We have heard nothing. I expect, Matt, that it's come down your direction. But when do we get a reply? You cannot expect us to come here hat in hand over and over and over again with no response, no genuine response. I was here when, right after the Firestone fire, all these people came down here and spoke, and immediately you went and approved several hundred drilling permits right after that fire, even with the Court of Appeals decision, which is the law of the state. How can you explain these things? How can you explain them? You know, you've got 600 ducks out there. There is no reason to give any more drilling permits. They are going broke. And it's going to be our job to pick up the pieces and pay for all the damn environmental damage they've done out there, because they're not going to pay for it. And the $200,000 limit isn't even close to what it's going to cost. It's going to cost billions of dollars for us to fix up the mess. I see it. I see it. These are my 3 minutes. And, you know, there's no fame.
Amazing what millions of lives will die. Keep it up and we will clear this room. I'm not kidding. It's going to be civil.
Okay, next up is Shayna Oliver, Julia Williams, and Randy Webb.
I'm Shayna and I reside in Denver, Colorado, 2301 Kearney Street. And I'm here to present myself and represent my family. As well, I have joined the Moms Clean Air Force since fracking has been opposed since it started. So I was born on the Navajo reservation, so I am an enrolled tribal member. And I was born with a birth defect, and I was diagnosed with asthma within 12 months of infancy. My mother was born with a birth defect. My grandfather was forced into early retirement due to his frequent asthma attacks. And both my grandparents, my great-grandparents, both died from some form of cancer, which cancer has become the second leading cause of death on the reservation, as well as first cause of death is unintentional death, which fracking comes under that. Now, nearly 2,000 people have died from fracking incidents across the nation. And that number seems to be growing every time we come to these hearings, and now you're thinking of appealing the Martinez case, which I think is very irresponsible for your organization to go through with this, ignoring the people and their right to safety and health, as well as for the fact that the U.S. government is a private organization, which is under a corporate charter number. So if you're going to enact your position as working for the people, you might want to start making your decisions in line with the law instead of policies. And these policies go against the constitutional law of our safety and health and the environment. For these laws were set to protect our future generations. It wasn't meant for corporations to be used, because corporations have no rights, as people have rights. So you're supposed to be working for the people, not corporations. And that I ask for you to think of the unborn children and their right to water, to land, and clean air. We all need those things, and to ignore their existence is to ignore your own existence. So please think about the future of the unborn children and not repeal the Martinez case, and not to stop fluffing the bed for the corporations.
Thank you.
Hi, my name is Julia Williams. I live in Lakewood, Colorado, and I am here representing both myself, my friends and family, as well as a representative of 350 Colorado. The Colorado Tourism Office describes Colorado as a year-round destination with unparalleled adventure and outdoor activities, a rich cultural heritage, and a growing food scene. Sounds like a pretty awesome place to live. What it forgets to mention is the not-so-picturesque 129,000 oil and gas wells that fill the skyline. It fails to warn visitors that Denver was ranked the 8th most ozone-polluted area in America. It neglects to forewarn of the 3.4 million acres of dead trees that act as kindling for deadly and destructive wildfires. The reality is our state is changing, and it's changing fast. Climate change is here. The impacts are real, dangerous, and worsening every day. The COGCC continues to ignore the climate impacts of oil and gas. Not only do we know that carbon emissions contribute to climate change, we know methane is a potent greenhouse gas with a global warming potential more than 100 times greater than carbon dioxide over a 20-year time frame. Natural gas is the largest source of methane emissions in Colorado. The combustion and flaring of oil and gas releases carbon dioxide, and the extraction process results in significant methane emissions. Due to improper enforcement of regulations and research on methane leakage from fracked wells, Colorado has seen wells with leakage rates of over 4%. This leakage offsets any potential natural benefits over coal. Colorado is already experiencing the impacts of climate change. Our average temperature has increased by 2 degrees Fahrenheit in the past 30 years, and projections say the state average temperature could be 5 degrees higher by 2050. 63 of 64 Colorado counties have been affected by at least one federally declared weather disaster since 2010. Our wildfire season is 105 days longer than it was in 1970. In fact, the 10 largest fires in Colorado's history have occurred since 2002. Climate change will impact our health through extreme weather events, increased infectious diseases, water scarcity, worsening mental health, increased allergens, heat stress, air pollution, food shortages, and more. Not only is Colorado just an oil and gas state, it is a mountain state, a state whose livelihood depends on the snow. Job security is a health issue, and climate change threatens the jobs of thousands of Coloradans, especially those that work outdoors. This includes the ski and ride industry, which employs over 46,000 individuals. It is the COGCC's statutory obligation to protect public health and safety and welfare, including the protection of environmental and wildlife resources. Failing to consider the climate impacts of oil and gas is failing to uphold your statutory duties. By continuing to approve new permits for wells and failing to properly research and regulate methane leakage, you are failing to protect Coloradans.
Thank you. Who's next?
Do we have Randy Webb?
Hi, excuse me. This is Randy Webb, and I live at 12854 East Villanova Drive. That's Aurora 814. This morning, a visiting out-of-state preacher friend read to me Psalms 37 to help me focus. So I'm philosophical today, and I hope that you will be too. I hope that you will take philosophy, your moral and soulful ideas as you consider the comments, the scientific information, the personal pleas, especially those of the next generation in their lawsuit, and the expressions that they have made before you before. I have been here since 2011 as far as coming to your meetings and learning about the oil and gas development. So it's hard for me to understand, why am I here today? I thought the first purpose of all good government, which you should be a part of, is to protect the people's health and safety. Most recently, it was wonderful to hear the Colorado court agree. But you seem to be doing business as usual. it's a strange thing why that continues. I hope that you will take into consideration the words of W. Edwards Deming. That is, while we're asking you to change your focus, he says, it is not necessary to change. Survival is not mandatory. And in conclusion, I, like so many of the people here that are speaking today, as unpaid volunteers who are busy with our lives besides speaking up, that I am here because of Naomi Nye's words. Walk around feeling like a leaf. Know you could tumble any second. Then decide what to do with your time. Thank you.
Thank you.
Okay, next up, we have Gina Handon, Melissa Penn, and Allison McGinty.
Hi, I'm Jenna Hardin, actually, and I'm chair of 350 Colorado, speaking on behalf of 350 Colorado, as well as really everything I love and value on this planet. I live in Denver, Colorado, 80211. The Colorado Health Institute just released this report, Colorado's Climate and Colorado's Health, examining the connection. And I'd like to admit this into the record.
Hearing officer after you're done.
And I'd also like to read just from the summary of that report. The Colorado Health Institute is a nonpartisan nonprofit. This is its first report on climate change. The American Public Health Association has designated 2017 the year of climate change and health, calling climate change the nation's greatest public health challenge. This is up to you. The rising temperatures, Colorado's average temperature has increased by 2 degrees Fahrenheit in the past 30 years, significantly outpacing historical trends. Extreme heat affects cardiovascular, respiratory, and nervous systems. Coloradans that will be most impacted are almost 6% of Colorado's adults who have cardiovascular disease. The state's 1.2 million children are especially vulnerable. The 711,000 seniors over 65 are at increased risk because chronic illness and age can hinder their ability to regulate body temperature. The 7% of Colorado's adults with diabetes are at high risk. Regarding air quality, changes in weather patterns, even slight modifications of wind temperature, humidity, or cloud level, increase pollutants such as ozone, carbon dioxide, and particulate matter, which in turn impact overall air quality. Coloradans most impacted, seniors with bronchitis or emphysema, the 107,000 children with asthma, the approximately 380,000 adults with asthma, the 180,000 Colorado adults with respiratory ailments, Coloradans who are prone to pollen and mold allergies. Wildfires. Climate and weather strongly influence the health of forests and the intensity and size of wildfires. Health implications include asthma attacks, coughing, chest pain, and eyes and nose or irritation. Vulnerable Coloradans include Coloradans who live in the wildland-urban interface areas, more than 2 million residents in 2012. Coloradans with COPD, asthma and lung cancer, people with cardiovascular disease. Given the rapid advance of clean energy and storage, the competitive to less expensive and decreasing cost of renewable energy,
and the explosion of the number of renewable energy jobs, even if a cost-benefit analysis were the appropriate test, which Martinez says is not, the harm of continued drilling would far outweigh any benefits continued drilling is causing. By continuing to pave the way for more and more intense oil and gas development, COGCC is leading the way to a disastrous future for our children. And I just ask you to ask yourselves, what is evil? Thank you.
Okay, who's next?
Hi, I'm Melissa Penn. I live in Old Town Lafayette where I rent a home. I'm about less than a mile from the 217 planned wells. I'm also what Colorado loves to hate. I am an East Coast educated Ivy League graduate Californian from Northern California. Did you ever hear of the Monkey Wrench Gang? Hi. Ever hear about people chaining themselves to old growth sequoias? Ditto. Every war protest? Yes, been there. I also direct and lead startups. I'm the director of strategic planning for a new tech-based Colorado medical company called Take Two Health. You've heard all the facts. The AMA is against this. Fracking's bad. This isn't news. Our currency is fiat, so if you want to support paper, keep going the way you're going. But here's what I wanted to say. Your governor has done something audacious. He said that Colorado is going to be the #1 medical initiator in the country. I laughed. I'm on the Prime Health Initiative Committee. We're helping to build these tech companies. We're helping to fund them. I'm less than overwhelmed. I've gone to the 10-10-10 Health 2017 Summit here in Denver. I would love to go home to California when I'm done, like the fracking companies, take my money and go home. In fact, I probably will. And I would love to downgrade you. Say Coloradans are lame. They wouldn't know a health initiative from a hole in the ground. There's a part of me that would love to do that. So I'm saying to you today, why don't you prove me wrong? Why don't you help your governor make this the healthcare standard for the country? Why don't you understand that your own universities have said that fracking is the worst thing that you can possibly do to any living thing? Why don't you understand the science and believe it? Because I do have a science background that says that this is a really bad idea. You have an amazing constitution in Colorado. I've read it. And it basically says that citizens and their health are more important than anything else. So I'm double dog daring you. Why don't you uphold your constitution and prove me wrong? And when I decide to stay in this environmental paradise, because it is the best place on earth, you'll know that you've done your part. Thanks.
Thank you. Who's next?
Allison McGinty. All right, Alana Cohn, Joseph Zemek, and Lauren Petrie.
Hi, my name's Alana Cohen. I live at 17060 Carlson Drive in Parker, Colorado, 80134. And I'm just going to be super brief. I just think we need to make sure that fracking has a minimal effect on the environment and public health, and that we should turn more to renewable resources so that we can help protect our lovely planet.
Okay, thank you.
Joseph Zemek.
Will help. There you go.
That's better.
Hi, my name is Joseph Zemek. I live on Lowell Boulevard in unincorporated southwestern Adams County. And I'm here to speak in favor of the Martinez ruling and to ask that the appeal process be stopped. There's concepts in the Martinez ruling that use, those concepts refer to your duty, your responsibility, and your obligation. Those words have policy implications, but they also have fundamental moral implications. You are to serve the public, you are to prioritize the public good and health and safety. I recognize that petroleum extraction has a long history and it's not going to stop overnight. What is important to realize is that future generations are being impacted by petroleum extraction, as well as people who are in its immediate path right now. I know a lot of people in Adams County, in cities, who are seeing fracking move into their neighborhoods, in Broomfield, in Thornton, and Brighton, especially. And fracking is for, a multitude of reasons, not subject to regulation at the municipal level. I think that's a problem. I don't know how much you can do about that, but certainly it's not a fun position for people who live in these cities to have to go to the state, and then you here at the state are saying, oh, it's safe, we're just going to keep permitting these operations like the Ivy site in Thornton, when other industrial activities are kept out to a great extent by the decisions that city councils are able to make. So there's a responsibility that you have, that because other people aren't able to take that responsibility. And there's a moral component to that. Whether or not you live in those cities, your decisions impact the people who do live there. And so you need to consider them, you need to consider their children, you need to consider their grandchildren. Obviously, any fossil fuel extraction is going to end someday. It is not sustainable. It is a finite natural resource. So one key aspect of public good and serving it is keeping that in mind. It's going to end. Let's look at ratcheting it back where it makes sense to do so. And I think a very sensible boundary is city boundaries. Let's not have toxic, loud, unpleasant industrial activities come into cities when the cities aren't able to do anything about it. But that is a decision that you can make. So when it comes to issuing permits for fracking within municipal boundaries, this is where the Martinez ruling compels you to say, consider that public good, balance it with that extraction. The extraction can happen in areas that aren't impacting dense neighborhoods, which is what we've got. That's where the growth is happening. You know this. So I wouldn't be here if I didn't think you weren't fundamentally decent people. If I thought you were not decent people, I wouldn't bother trying to change hearts that I don't believe could be changed. I know that you are capable of keeping this information within you when it is time to have those meetings and look at those permits. Thank you.
Thank you. Okay, who's next?
Lauren Petrie.
Hi, sorry, I'm not this tall. Thank you. Hi, thank you. My name is Lauren Petrie. I'm here on behalf of Food and Water Watch, our statewide organization representing thousands of supporters across the state. But I'm also here as a resident of Denver. And I want to just point out that the Colorado Oil and Gas Conservation Commission, you should all change your name to the Colorado Oil and Gas Collusion Commission, because you are not representing the public in any way, shape, or form in anything that you are doing. You've ignored the public for years, and you continue to ignore the public at meetings like this. Your agency and its regulations or supposed regulations and the process that you're using for issuing permits is a total sham. Your agency is also ignoring the rule of law, not just the public. The Colorado Court of Appeals ruled in March that protecting public health and safety and the environment is a precondition that must be met before you can issue permits. And you are not doing that. And your process has not changed since that ruling. But if you ignored the ruling, just like you're ignoring the people, you're continuing to steamroll communities with thousands of wells right next to their homes and schools. And all you're doing is considering the oil and gas's bottom line. That's the only thing you're considering. You're not above the law when it comes to the Court of Appeals ruling. And with every permit that you grant, you're all planting ticking time bombs next to and underneath people's homes and schools where they live and work and recreate. You are putting people's lives at risk every single day, and you know this because there have been several explosions in the past 2 months. And if you think that I'm being hyperbolic about that, I just want to put this in a little bit of perspective. If you owned a restaurant, Director Lepore, and you had an employee that was causing 2 cases of food poisoning every single day, how long would that person work for you at your establishment? The oil and gas industry, they average 2 spills a day, and that's only what's reported. That's not what we don't know about, and that's not what you don't know about. And this agency doesn't even know where pipelines and gathering lines and where all of the old and existing wells are. You guys don't even have all of the information for the process, your own process. It's negligent. So I want to conclude by saying, when you go home and you kiss your families at night, I want you to know that you're destroying the lives and the families of other people across Colorado. And if you don't mind breathing in the pollution, the contaminated air, and you don't mind living next to a ticking time bomb, you think fracking is great and you want it in your backyard, that's good. Good for you. But don't you dare force it on everybody else that has already spoken out in opposition. That is just not right, and you know it. So we're here to say we want you to stop the Martinez appeal. Let these 6 youth fight for their right to have a livable future, a livable climate, clean air and clean water. You wouldn't want somebody taking that away from your kids or your family, would you? Put yourself in the parents of those children's position when their children are being told that they don't have a right to clean air and clean water because the industry's profits are more important. You need to stop the appeal, stop the permitting process, and you need to rescind all of the permits that you've already issued since the Martinez ruling because you have not met the preconditions for protecting public health and safety since then. Thank you.
Okay, next we have Brian Kane, Sabrina Arnovitz, and Carol Sauer.
Honorable Commissioners, Director, thank you for the opportunity to provide comments this morning. Good morning, my name is Brian Kane. I represent Extraction Oil and Gas. In support of our spacing applications filed on July 13th, I'd like to provide an update of our continued work with local officials and community members in Broomfield. Over the past 2 years, we've been working collaboratively with Broomfield City staff, elected officials, citizen volunteers of a special oil and gas task force. Due to this engagement, we have held off on filing an APD to date. Extraction Oil and Gas originally filed spacing applications in Broomfield during the summer of 2016. Since that time, we've withdrawn, amended, and deferred various applications at the city's request in an effort to demonstrate a spirit of collaboration and engagement with the city and its residents as they've taken important steps to familiarize themselves with the oil and gas development process. We have additionally taken steps to reduce impacts and inform the task force. And these steps include, but are certainly not limited to, moving 40 wells out of Broomfield to our Coyote Trails location, adjusting spacing applications to reflect edits requested by by the city of Broomfield. We've engaged in air monitoring and noise sampling at 3 separate locations over a number of weeks to demonstrate the safety and extremely low impact nature of our operations at the request of the task force. And the data is in on those, and it is outstanding. This also includes the inclusion of industry-leading best management practices and closed-loop systems in our design, which include the use of an electric rig, one of the world's only quiet completion fleets, and pipelines to move oil and gas resources. We have also participated in a thorough third-party air modeling exercise using EPA-approved air mod parameters. To my knowledge, this is among the only instances of an E&P operator doing so in Colorado for an oil and gas drilling pad. We've engaged in numerous presentations to the Broomfield Task Force and to Council. We've provided facility tours of 6 locations for the Broomfield Task Force, as well as for council members. We have engaged in numerous meetings with and on-site field visits to plan and secure pipeline right-of-way. And again, we've withdrawn, amended, and delayed spacing applications on numerous occasions at Broomfield's request. We respectfully ask that our applications be heard in September so that we can continue safe and responsible development of our energy resources while moving ahead with completing the task force process in Broomfield, which Broomfield staff has said in public meetings should be wrapped up in early August. So we believe it's entirely appropriate that this be heard in mid-September. And before signing off, I would just say, I believe that ours has been a unique process, a unique and thorough process. It is one of engagement and collaboration that we're extremely proud of. We thank Broomfield, and we hope that this becomes a model for our industry. Thank you for your time.
Okay, thank you. Who's next?
Sabrina Arnovitz.
Hello, my name is Sabrina Arnovitz, and I'm a community member, and I just want to say that most of what that guy said is BS. The gas and oil industry never really talks to communities in a way that's helpful or responsive, and all they do is really destroy communities and poison the water and the air. You've been listening to people talk about the hazards of fracking and climate change all morning, as you've done before, and you probably read studies on the subject, all which you've chosen to ignore, that say that fracking is dangerous. So I'm done asking politely for you to listen to our questions and respond to our demands. You have blood on your hands. By allowing new permits for gas and oil, you are killing people. When a child gets asthma in high school and has to drop out of their soccer league, which happened to me when fracking entered my neighborhood, it's your fault. When a house blows up from a faulty well, it's your fault. When a pipeline breaks into a river and poisons water for millions of people, it's your fault. When people are beaten by cops for putting their bodies on the lines to stop these projects, it's because of you and your eagerness to appease the gas and oil industry instead of actually listening to what this community is telling you. People are getting angry about this, and they're getting angry at you as well in the gas and oil industry. People are going to have to start stepping it up and doing more to protect their homes because you aren't listening. So when that escalates, it's also your fault. When people are hurt, it is your fault. Don't forget that.
Okay, thank you. Who's next?
Carol Sauer.
Hi, I'm Carol Sauer, and I actually live in Lyons, Colorado, and I didn't know you were having this meeting this morning. I actually came down about a docket that was for a permit for a well in the neighborhood where my mother lives, and I have set for her. And so as a conclusion for me, listening to all these folks be very disgruntled with the Oil and Gas Commission and all, it's very interesting, and I really do concur with him and agree with him on many fronts. On an individual level, we received a notice that they're drilling a well near us with 8 pads. But in this notice, we had a very short time to respond and actually got the notice after the time that we could respond that we had a question or an objection. So I tried calling to find out this information. And so far I haven't gotten any responses. So I was going to take this up later at the meeting, but I decided, well, I don't know when that is, sometime today or tomorrow, which means I have to camp out for literally 2 days to know some information, very basic information. How close is this pad going to sit to our homes? All the people that live near us, and we're actually, my mother lives out in the country, but actually fairly close to town. And there's already a huge pad that sits very close to town, to the subdivisions there. And when I go look at the map of where potentially they can sit these wells. It's actually in a subdivision, which by law, they're required to report they're going to be near this subdivision, but it doesn't say they're not going to drill where they're potentially going to develop later. So I just have a suggestion that when you send notifications, something that maybe you can accomplish, that you actually send a little more information with the maps, and that you include more people that are considered interested parties that are being notified. Maybe publicly posting it, that if you go to get a building permit in Boulder County or Larimer County and you want to build a big building, you have to post a notice for several years before they'll let you build that building. And they have to, your neighbors have to approve of a building being that big. So it doesn't seem that the same thing applies if a pad sits really close to us. And this notice said that potentially they could drill 8 wells. But where? I have no idea where. So the only way to find out was to come down here and try to camp out for however long it was to ask a simple question. So I decided, well, this is the best chance to make this heard, since I don't know when that is. And maybe people here needed some particulars of when permits are being applied for, some things that are being missed by the commission, of informing the public. Because when I looked at the map, you have the map of where all the wells are and how far out they've drilled. But some of those wells actually sit right in the town of Eaton. So it was of great interest to me that we now have people from Firestone and Broomfield protesting, but I don't think anyone in the Eaton area actually knows of what's going on next to their community either. So maybe just a little better information for folks that are being requested to respond. Do you have any objection for the permit? Do you have any objection to where they sit the pad? There wasn't even time to respond to that. So that's just my comment. And when you go to look at the dockets, it might be nice to say approximately this time, so people actually know they can show up at a time and not have to camp out, because some people just don't have time to camp out for 2 days, even though it's in their best interest.
I would encourage you to get with the staff.
Okay, I tried, but I will continue to try. And thank you.
And may I just ask, is this a matter that's on the agenda today, and is that why you came, ma'am?
Yeah.
Do you know?
It just says 9 o'clock in the morning. And so you have a huge public meeting going on. So you have to wait, because their docket starts after that. So they have no idea really when this is going to occur. So they're up against the wall that way. But it seems like some things could change within their own department to help them out as a staff to deal with these issues and to address public concerns on a smaller basis before it escalates to a large basis. And maybe then they would have more input before these things become so huge and dynamic like this, which is happening in Colorado. And my last comment is for all these folks, it's just a comment. I live in Lyons. My mother lives in Eaton. You can't see the mountains anymore. I grew up in Colorado. I grew up in Denver, refining plants on the edge of Denver, and it was smoggy where I grew up. I grew up in Hudson, 30 miles out of Denver. By the time I grew up, they had started to clear off all of that for cleaner air in Colorado.
Please summarize.
And so when you go to Lyons, it's clean air because the mountains stop the smog and the pollution that's coming off the front. I live near, when I go to visit my mother and stay overnight, she lives near several large pads that off gas at night, that burn at night, and everybody's sick in the morning. We have a direct correlation to how this affects us. It's just a comment, and that's why I don't want another pad too close.
Right, and I completely hear what you're saying. I unfortunately don't know which proceeding you're talking about. I'm not sure is it something that's on the docket for today? Because if you can, okay, can you point me to which one it is? That would be incredibly helpful.
Okay, it's docket 170700472.
Okay, thank you.
Okay, thank you.
Okay, who's next?
That is all that have signed up, Mr. Chairman. I would call your attention, however, to a Rule 510 statement that was submitted by Pam DeWitt that did not make it into your portfolios earlier, but you have a hard copy in front of you.
So is that going to be the statement, or are they going to come speak?
I do not believe she signed up. She submitted a written statement.
Okay, so this is in the record?
It will be, yes.
Okay. Okay, who's next?
We do not have any other people signed up.
Can I speak, please? I couldn't get near the microphone, near the.
Sign up paper? Yes, ma'am. Come on up and give us your name and your address.
I sure will. My name is Cleo Diolettes. I live in Denver, Colorado, 9625 East Center Avenue. I am 70 years old. I want to live another 30 years. I want to make it actually to 100 because, you know, we're living longer, supposedly, okay? When I look at all of you and I watch all the people speaking, you look disinterested, you look disinterested, and you all look disinterested. Why? Because in my estimation, you are all paid off by the oil and gas company. You could give a damn less about us. You don't care. Well, I worked in the medical field for over 35 years and I saw some of the issues. I had friends who had children with bleeding noses in Commerce City where you fracked, where you allowed the fracking. You don't give a damn about us. All you care about is the oil and gas company. Well, I want to tell you something. I moved to this state in 2000. I thought this was the greatest state on earth. I moved from the East Coast. I moved from Indiana. I moved from other states. You know, if I don't own a home in this state, I'd move out of it. And I would tell everybody not to move in it. You don't care about your people. You just take our taxpayers' money. But I've watched you through all the other people that presented here today. Nobody got angry, but I'm damn angry. You should all be ashamed of yourselves. You all are not, you cannot take your money to your grave. You cannot. And I am so upset watching you. You have been the only courteous person I want to say, and I don't know your name, Erin, I appreciate that. But I want to tell you guys, you just don't know how much anger there is in this state. You have no clue because all you speak to in private is the oil and gas companies. You have no idea. There are people who want to sell their homes because of fracking and they can't because nobody will buy it. They won't buy their homes. Thank you for letting me speak. But you people, you disgust me.
Okay, we're going to take a 15-minute break. To order. We're done with
No
the,
more business as usual. No more drilling, no more permits, stop the appeal.
we're gonna take
No
another
more
10-minute
drilling,
recess.
No more
Out
permits,
of the-
stop the appeal. No more drilling, no more permits, stop the appeal. No more drilling, no more permits, stop the appeal. No more drilling, no more permits, stop the appeal.
We're gonna take a 10-minute recess. I know there was some questions about consent.
And if I may, just before we move on to our regular business, I know that we took a break and cleared some people from the room who were disrupting the hearing, but I did want to make sure that that we were allowing members of the public into the hearing room so long as they were being civil and not disrupting the hearing. So just wanted to make sure that we were allowing all members of the public to.
Absolutely, we're not shutting that down.
Great, thank you so much.
Hearings officer, did Ms. Durante have something she wanted to say before we started consent?
Yes, I believe there were 2 or 3 cases that were set as contested hearings that have now settled, and they did not make it back onto the consent agenda in time because we'd already sent out the portfolio and they didn't settle till Friday afternoon and the weekend. So I believe she has a presentation to tell you what those are all about.
So excuse me, Bill Durante, hearing officer. It's docket number 1705-00267 and 1705-00268, which are the Great Western Operating Pooling applications. They were protested by Horizon Operating, and those have been resolved. The protest has been withdrawn. A copy of the draft order on each of those applications was placed on your desks this morning, as well as 1705-00245, which is a BDC versus Verdad. That matter also resolved on Friday, and a draft order was also placed on your desk this morning. So those matters would be moving forward as uncontested matters, and we would request that they be approved on the consent agenda.
Okay, commissioners, questions of staff?
Oh, it doesn't concern those 2 matters.
Okay, thank you.
Thank you very much.
Okay, I think there was further questions about Group O.
Commissioner Boygan, would you like
Well,
to?
I just wanted, I'm not sure when the appropriate time to state my relationships with parties on the consent agenda.
We'll get to that.
Okay.
So it's hard to see you over there. So yes, I did have some, I wanted to just provide a little bit of background about the item that's on the consent agenda that's in Group O. This is a spacing application that was filed by Great Western, and there were a number of both surface and mineral owners who filed protests in that matter, and that those protests were afterwards converted into 510 public comments, and some of the individuals who provided protests that were converted to public comments appeared here this morning at the public comment hearing, and I appreciate them taking the time to come and speak to us about those matters. I wanted to just provide a little bit of additional clarity, because in the pre-hearing order that resolved those protests and converted them to 510 public comments, there was direction to those parties to address that the concerns they were addressing were better addressed in a Form 2A context. And so, however, there were some additional issues that were raised by those protests that may not necessarily fall within the scope of a Form 2A. And so I wanted to make sure that we were providing sufficient information to those protesters that were converted into comments about where the appropriate place for them to engage in the process was.
Mr. Lepore or Mr. Durante.
Well, thank you very much, Commissioner. As indicated in my order, I did hold a pre-hearing conference on those matters. I did give the opportunity, the parties an opportunity to supplement their statements that they provided to me in writing. In addition, the comments that they made, I indicated could both be made during the Form 2A process, as well as to any of the environmental manager or the engineering supervisor. And I did indicate that in my order, which was provided to all of the parties. So I provided to them a number of different parties that they could communicate with to further answer any additional questions that they had. And at the time, and in the document, I also provided them telephone numbers of their municipal as well as their county local governmental designees, so that they could raise any concerns that they had with respect to the value of their properties. I know that that was some of the concerns that they had, or any other questions that they had that could be answered by their LGDs. I provided that information to them as well. So if there's anything additional that you'd like me to provide, I can certainly, supplemented or provide any additional information to them after the hearing.
Well, I was hoping that we would be able to have this conversation with them here so that we could provide that information to them, but I appreciate what you included in your order. And I wanted to just be sure that the public was understanding, because I know that this can be sort of a difficult process to understand all the different steps, that there's spacing, and then there's pooling, and then there's the Form 2 and the Form 2A, and there's various places where an impacted member of the public can sort of engage. Some of the issues that were raised, like for instance, the property valuation impacts, the seismicity concerns, and there were some concerns about forced pooling and the sufficiency of the lease terms. Those are not necessarily appropriate to be considered in a Form 2A, and so I wanted to just make sure that we were providing sufficient information to them that they knew the appropriate place to get involved and to get engaged.
Certainly. In the conference that we held, all of the parties, almost all of the parties, I believe 9 of the 10 parties were present on the telephone, and I did advise them that this was a spacing application, that there was different stages prior to development, and that this was only spacing. A few of the parties did mention that they had received lease offers by the operator. Counsel for the operator was also present on the phone and did address that briefly. And I did explain that after the spacing and the pooling applications, and if they are approved by the commission, at that point there would be Form 2s and Form 2As that would be submitted, and that they would have an opportunity to comment at that point. So I did explain the stages of each of the process, so that they could know at which point they would want to participate, at which point that they would want to object or comment or protest if appropriate.
Okay, great, thank you. And I have just one other matter just in response to the public comment that I would like to clarify before we move on to the meat of the consent agenda, which is that a number of the commenters raised a concern that the process of approving uncontested pooling and spacing orders, as we do on our consent agenda, was inconsistent with the Court of Appeals' ruling in Martinez, because there was no stay of that order issued pending certiorari review by the Colorado Supreme Court. And so I was wondering if I could put our Attorney General on the spot to address that issue of whether or not a stay has been issued on the Court of Appeals' ruling, and when that stay was issued.
Thank you, Commissioner Overturf. I would direct anyone who's curious about this issue to the very last page of the Court of Appeals opinion in Martinez, and it's a document titled Notice Concerning Issuance of the Mandate. And the mandate is the Court of Appeals essentially return following their decision, giving the lower court jurisdiction in regard to their remand. And the final sentence of that notice says, filing a petition for writ of certiorari with the Supreme Court within the time permitted by Colorado Appellate Rule 52B will also stay the mandate until the Supreme Court has ruled on the petition. And so that's what, if you're curious about the effect of the Court of Appeals ruling and how that proceeds during an appeal to the Supreme Court, it has been stayed thanks to the petition for cert.
Mr. Chairman, I'm sorry, could I weigh in on that?
Sure.
I'd like to, I thought about that when the issue was raised by our commenters, and I think there's some misunderstanding about what the decision actually does. It's a pretty narrow decision that only interprets the legislative declaration. It's not self-executing in the sense of applying to or interpreting a substantive provision of the act, and it was in the context of a requested, it was a petition for rulemaking, which the commission had denied on the theory that it didn't have jurisdiction. And so the result, as I construe it, the result of the decision, if it were upheld, would be to send it back to us to consider the merits of the rule, and also presumably to consider the impact of the interpretation of the legislative declaration on the substantive provisions of the act. The governors and the governor's council were of the view that the decision didn't change things from what we already do as a commission. And for that reason, they thought an appeal was unnecessary. So there are obviously differing points of view on that. But I think the notion that the Court of Appeals decision, if it were not appealed or if it just were summarily affirmed would mean that all permits issued by the commission had to stop or were illegal is just not a fair reading of the decision.
Okay, commissioners, anything further?
I have one more question. This is back to Group O on the consent agenda. The question raised by public comment about the seismicity, I don't believe that's something we generally look at on Form 2A. Is that handled by city or county instead of COGCC?
Thank you, Commissioner. So I think there's a bit of general education involved with respect to induced seismicity. In Colorado, our experience with induced seismicity has been limited to underground injection control wells. There are instances in other states of fracking leading to seismicity. But generally, we would advise that unless there is a underground injection control permit being sought, sort of outside the scope of the Form 2 or 2A for a particular well pad or wells. We do have a complete permitting process for underground injection control wells that do include Form 2s and 2As for those wells, as well as Form 33 and maybe 36 or 34, I'll probably get it wrong, but there are two separate permits for the underground injection control wells. So we would advise anybody who raised that issue of all of that process, and they can comment on those underground injection control well permits just as much as on the 2 and 2A. It is also true that because there is no mineral right associated with the disposal well, we often are asking local governments to evaluate those locations before we approve them. And especially in those situations where we are aware that there's some public concern about the location. So there is a public local government, sort of local jurisdiction question there. Then that might be another fruitful avenue for expressing concerns about the location of an underground injection control well.
Right. So I just wanted to make sure that the residents who have concerns about their structural foundations and potential effects from oil and gas can get some answers and some knowledge, and we would recommend they go to the local government.
I mean, I think we would talk to them too, and it might be the right place to have them talk to the engineering group about that. There's some point in that process, if they actually have a claim, they believe that the drilling or hydraulic fracturing resulted in structural damage to their home, that sort of moves into the civil court scenario. But as far as, commenting on a permit that they don't want the location for their concerns about hydraulic fracturing, I mean, they can put those comments on a Form 2 or 2A. I'm not sure, what mitigation measures we might have at our disposal, except considering the location.
Or communication and education of the potential risk.
Right.
Thanks.
Okay, anything further? Okay, let's consider the consent agenda. Group A through V. Is there anybody that needs to recuse off any of those items?
Mr. Chairman, I would just like to point out that I have in the past done legal work for Extraction and for Crescent Point. Those projects don't relate at all to the matters on the consent agenda. They don't involve commission work. And I think that I can be impartial in my decision-making on those matters as well as on the others.
Okay, commissioners, anybody have a problem with that? Okay, entertain a motion approving the consent agenda, Group A through V. Motion by Jolly.
Second.
Second by Hawkins. All in favor?
Aye.
Opposed? Motion carries. Okay, enforcement orders, Group A.
Mr. Chairman, I assume that vote approves the matters that Mr. Rancy brought before you that didn't make it onto the consent
Yes,
agenda?
the entire consent agenda. There's some comments on geotech production.
Yes, Acting Chair Holton, thank you. David Beckstrom, Assistant Attorney General for the staff. I just wanted to make a verbal modification to the geotech order. There was some typos in there regarding dates on a payment plan. If you refer to Bates page 16, paragraph 2B, Romanet 3 and 4, those dates were put as 2017 and should be changed to March 23rd, 2018 and July 23rd, 2018 for the last two payments on the penalty in that order. I would ask that when you vote with those modified dates in place.
Okay, Commission, questions of staff?
Question on the petroglyph.
Absolutely, yes. And I will mention Nicole Colby from Petroglyph is present, so she might also be able to answer questions if I could ask her to join us now.
Commissioners?
Go ahead.
In the reports, it mentions 55 remaining wells that aren't part of the subject at hand, but I was wondering what the status of those 55 wells. Are they all P&A'd?
I will defer to Ms. Colby for that answer.
Thank you. Nicole Colby, I'm the Land and Regulatory Compliance Manager for Petroglyph Operating. Those remaining wells are P&A'd. We do have surface reclamation duties remaining that are reflected in the work plan presented to David.
Why is there still surface remediation necessary if they've been P&A'd? Shouldn't that have been done when they got P&A'd?
The reclamation work was started, but it was not finished, and they have not yet passed final approval for reclamation. So the work that's remaining to be done is some reseeding, making sure that weeds are controlled, as well as removal of some debris left on location. But the reclamation work was commenced. It just was not completed to staff satisfaction yet. This plan is to get them on course to do that in a more timely manner.
Is the company got the financial solvency to rectify or remediate these well sites?
We do. We've set forth a budget and a schedule in our work plan with the commission that was the subject of the AOC development. And yes, we're committed to a 4 to 5 year plan to get those reclamated. And just briefly, the history, a tiny bit of this, the reclamation efforts started in 2011. We had environmental contractors on site doing work toward ensuring the vegetation remediation for periods in 2011, 2013, 2014 was the year that we missed due to some of our obligations in Utah with our operated wells. And so then we hit it hard again in 2015 and 2016. So I think we're really on a path to get them closed. And I believe our 4 year plan shows that.
Is the surface owner on board with this?
Yes, this is largely, the majority of the surface locations are larger ranches, the Martinez, the Andreatas, the Anselmos, and we're in communication with all of them, yes.
It's good to hear. No, thank you.
Commissioner, Mr. Chair?
Yes.
Commissioner Jolly asked some of the questions that I was going to ask, and some of my concerns relate in general to these types of matters, and we touched on this at the last hearing. So the way I understand this, there are phased penalties, or let's say reductions of the penalties as work is performed, which is fine. And then if the work is not performed, then all becomes due. There's no indication of what happens if the remaining amount is not paid. There's a settlement discount reflected in the AOC. I'm curious why the settlement discount wouldn't be revoked in the event the remaining payments are not made, why interest is not charged, why or what kind of security there may be, what kind of consequence there would be. There's an amount that'll be owed. What if it's not paid? And if the work's not done, so, and there's 5 years in this case to do the work, how are we comforted knowing that there's an adequate remedy to deal with that situation? You're on a plan that everybody seems comfortable with. Apparently, staff is comfortable that Petroglyph is solvent and capable of performing its responsibilities, but we don't want to be left holding the bag. So I'd like you to comment on that, if you would.
Absolutely. Thank you, Commissioner Boygan. The way that this case was resolved touches on a lot of the issues that you brought up at the last commission hearing, and one of the issues that staff tackles on a regular basis, which is how do we motivate operators to come into compliance, remain in compliance, especially when it comes to reclamation. Petroglyph currently has 60 oil and gas locations in the state. None of them are producing. They're all scheduled for reclamation. This order was created and designed to allow them to invest their funds towards the reclamation instead of towards a penalty. As you noted, should they fail to comply with the order, should they fail to meet any of those deadlines or pay the penalty, it would not only bring due all of the penalties under the order, it would also subject them to new penalties for violation of a commission order. That's a Class 3 violation. Those penalties escalate very quickly. That being said, should they be unable to pay the penalty for whatever reason, we are left with the prospect of these locations not having an operator to perform the reclamation. That really was the motivating factor for suspending the penalty to this extent, was to allow them to direct the funds towards the reclamation. We did not do an investigation into their solvency. We relied on statements from Petroglyph that they were solvent, that they did have the budget to do this, and that they were dedicating a significant portion of their budget to this reclamation. With that in mind, our objective was to keep Petroglyph in Colorado until they finish that project.
Mr. Chair, if I might follow up and perhaps you can respond. If these are their only remaining sites in Colorado, and if you're not currently in the permitting stage, if you're not drilling, developing resource in Colorado, yes, you have an incentive to reduce the amount owed by living up to your responsibilities, but if you were to just walk away and owe the money and owe the additional penalties, what would be the consequence if we didn't take some sort of collection action or enforcement action?
Right. Thank you, Commissioner. And I understand your concern. I think on one hand, we do have a significant bond investment in with various agencies within the state, both with the county, also with the city of Walsenburg, and with the state of Colorado. And I think I'm not certain that this will assuage your concern, but we have proposed a significant budget, and that money is set aside to ensure that the 5-year plan does occur. They have hired me to be there for 5 years. This is my sole, last month I was managing 1,000 oil and gas wells, all the land duties, and now this is my sole focus. We've acquired a contract with Habitat Management going forward, and with their consultation have developed a 5-year plan. So that may not assuage your concerns, but I think we were glad to sit down at the table and to work out a plan that can see us through to closing it on time and sticking around.
Look, I'm not second guessing the plan. I appreciate the plan, and I have no reason to doubt your sincerity, your good faith, and I'm encouraged by what you've said. And this really is kind of a larger issue. For an operator that has nothing else in the state, we have very little clout, leverage. Thank you. So I'm perfectly willing to assume that Petroglyph will perform its responsibilities, but if it doesn't, I'm not clear on where we go from there, other than we're assessing fines and penalties.
And again, the options available to us are assess additional penalties, as you noted. Should Petroglyph as you said, walk away from the state of Colorado without having any pending operations or active operations in the state. We would have the remedy of calling their bond and the statutory authority to pursue civil remedies should that be necessary. Outside of that, we would also withdraw their approval to conduct oil and gas operations in the state of Colorado. We've seen that before. We hope with every operator that that's never a circumstance we arrive at. That is one of the more extreme remedies available to us should that occur.
Well, this is a subject I'm going to return to, and I think we have to develop a longer-term strategy for dealing with this.
Commissioner Hawkins.
Just a observation or comment on that, your concerns. And I think I agree with you that once the operator has no further operations here, there really is very little leverage. The only other thing that I could see that might be workable would be to have some kind of an interstate agreement or memorandum of understanding or something of that nature that would allow us to at least have some kind of clout on if they have operations in other states. And maybe that's something Director Lepore has thought about with the IOGCC.
Thank you, Commissioner. I will confess to not having had conversations at IOGCC about interstate agreements about operators in these circumstances. It's something that we could consider. I mean, I agree with the overarching concerns, and we have engaged industry for the last year and a half on conversations about what we've dubbed it distressed operators, rightly or wrongly. There are a number of them we know of. There are a number we could guess about, and there are probably a number we don't know about that are right there. Starts with the financial assurance requirements and goes from there. So there have been discussions, Commissioner Boygan, for over a year now on some remedies to that. Other states, there are models in other states for either reclamation funds or plugging in abandonment funds that are separately, apart from the financial assurance requirements, those funds are maintained for a circumstance like this should Petroglyph ultimately not perform. And we have had those conversations, certainly with industry, at the executive director's office, and frankly, in the governor's office. I think those conversations need to move forward. And I will tell you that that likely takes legislation.
Right. I would just have two quick follow-ups, and I appreciate that. One is it would be useful to know what other states do, whether there are some models out there that are useful for us to emulate. And second, I have a question, and that is, you referenced the statute that allows the commission to seek recourse in the courts. I'm wondering if that's ever been done.
Not to my knowledge.
Okay, anything further? Okay, we'll consider a motion on Group A with the amendments made to geotech production as per staff.
So moved.
Motion by Hawkins.
I'll second.
Second by Boygan. All in favor?
Aye.
Aye.
Opposed? Motion carries. Firestone update, you want to do that now or you want
to? Completely at your leisure and discretion, Mr. Chairman. I will tell you that I think we can do Firestone and notice to operators in under no more than 20 minutes.
Okay, well, we'll go ahead and do that before we take a lunch break.
Okay. So, Mr. Chairman, I will begin on Firestone, but Greg Duranlo, our environmental manager, is really going to do the bulk of the update. I will just note that, as you're all aware, the National Transportation Safety Board is investigating the Firestone incident. They have one investigator in chief assigned to that case. I can't think of the acronym. IIC, investigator in charge. In any event, he has been preoccupied with other matters for the last several weeks. He is returning to the state, and we are recommencing fact witness interviews tomorrow. And those interviews are interviews scheduled for the next 3 or 4 days. And someone from COGCC, either myself or Mike Leonard, will participate in those interviews. And in fact, Mr. Leonard is one of the people who will be interviewed because he was very involved in the investigation right after the incident in April. So that's happening on the NTSB front. I think it's been fairly well publicized that the NTSB does not expect to finish its investigation and finish its report until at least about a year out from the incident. So we're looking at next spring or summer for a NTSB report on the incident. And not surprisingly, there is a great deal of litigation and many parties involved in litigation around Firestone. I mention that only to say that we have had experience here recently where that complicates getting things done. There are a lot of people who have an interest in, for example, a specific example is plugging and abandoning the well that was involved in the incident, and Anadarko agreed to plug and abandon 5 or 6 active wells that sort of encircle Oak Meadows neighborhood. They submitted notices of intent to plug and abandon those wells to the COGCC. But just recently, the parties to the litigation have weighed in and said that they have things they would like to be able to do before the plugging and abandonment actually takes place. So again, I'm only just apprising you that there are complexities here beyond sort of ordinary circumstances. And the plugging and abandonment is a pretty meaningful one that affects how we do or what we do. I think with that, I'll turn it over to Greg to talk about the remediation, investigation, and remediation of the hydrocarbons that were released into the subsurface as a result of the flow line being connected to an active well and having nowhere to go.
Thank you, Director Lepore. Good afternoon, Commissioners. At the last hearing, I reported to you that just prior to that hearing, Anadarko had been able to shut off their remediation systems, their SVE systems. 2 systems had been installed to remove natural gas from the areas of impact identified in the Oak Meadows subdivision. As you're aware, the 2 areas of impact were initially identified during COGCC's investigation following the home explosion. And those areas were completely delineated horizontally and vertically by Anadarko during their investigation. Anadarko installed the western SVE system on May 17th and the eastern system on May 24th. Both systems were shut down, as I mentioned, on June 7th. Post-shutdown screening of 63 monitoring points throughout the areas was conducted June 8th, the day after shutdown, June 9th, the following day, which was a Friday, and June 12th, the day we were in Meeker at the hearing. That was the Monday. During those monitoring events, no detections or rebound of methane or natural gas in the impacted areas were found. On June 19th, a week later, another round of screening from the 63 points indicated that 2 of the points had slightly elevated concentrations of methane detected, 0.1% and 0.2%. So really well below any concentrations of concern that had been, utilized throughout the project. To further establish that the gas removal was complete, Anadarko installed 9 new soil borings in the project area and collected samples from those for laboratory analysis. So we didn't want to just go back to the same exact points. We installed new points in between some of those points to make sure that gas had been completely removed. Those samples came back non-detect for methane and all other hydrocarbons. COGCC also required verification that there was no residual gas trapped beneath the foundations of 6310 and 6312 Twilight Avenue. Due to the configuration of the foundations, we felt that that was a potential as we'd been evaluating the project. Anadarko penetrated the floor slabs in 5 locations in one foundation and 4 in the other, collected samples again of the gas beneath the foundation for laboratory analysis. And those samples also came back non-detect for methane and other hydrocarbons. On June 27th and 28th, Anadarko screened and sampled again all 63 monitoring points. Since they had just prior done the 9 new points, they didn't add those to this survey, but they screened the 63 original monitoring points again, and no methane and other hydrocarbons were detected again. So multiple lines of evidence and post-remediation monitoring to date indicates that no detectable methane or hydrocarbons remain in the 2 originally impacted areas in the subsurface there. And therefore COGCC approved the removal of the SVE system components on July 11th, and Anadarko began that removal on July 17th. So the trailers that house the equipment have been pulled from the sites. It was 2 separate trailers. The above ground piping that connected the various monitoring points to the SVE systems were removed. Fencing, straw bales, generators that powered the equipment have all been removed. The monitoring network, the 63 points, will remain in place for a period of extended post-remediation monitoring. So we've identified with Anadarko a subset of those points that will be screened and sampled on a monthly basis for 3 months. And as Director Lepore indicated, we have seen the notice of intent to plug certain wells and remove the equipment. He also mentioned that the schedule may be in flux, but COGCC will have a presence both in the field and from a technical oversight review of the plugging activities and the equipment removal activities. That tank battery is at the sort of west end of Twilight. And that's what I've got for an update, and I would be happy to take questions.
Commissioners, questions, staff? Okay, seeing none, we'll go to the notice to
Sorry.
Oh.
Just quickly, Mr. Chair. It's very impressive what you've done. I'm curious how you developed the methodology. Was it a consensus of different experts retained by the commission, the companies, third parties? I mean, how did this, was it just kind of ad hoc, what seemed to be the right thing to do as things developed?
So initially staff was very reactionary and really just trying to move our investigation forward as quickly as we could. We did also review, there are some literature associated actually with the coal mining sector that talks about how to evaluate for stray gas in the shallow subsurface. So we were right on track with some of that methodology. The consultants that we used, had expertise in soil gas survey. Anadarko also employed a consultant that had, a great deal of expertise in subsurface investigations. So, pretty standard. In a way, it's very standard investigation in a non-standard situation.
Okay, further questions?
Thank you.
Mr. Chairman, I will then turn to the notice to operators, just a brief update there. I guess just to refresh everyone's recollection, there were 2 parts to the notice to operators. The first I describe as identifying point A and point B, the beginning point and the end point of all flow lines for all wells or production facilities located within 1,000 feet of a building unit. The idea here is that at Firestone, we had a point A, we had a flow line connected to a pressure source, but no point B, no end point. It terminated, the flow line terminated in the subsurface without being connected to anything. So get out there and make sure that every flow line connected to a pressure source has an endpoint, that the circuit, the loop is closed. And then, having done that, do an integrity test on those lines to make sure there's no leak in between point A and point B. All of that was required to have been done, that part in 2 steps. May 30th, identify that point A, point B. June 30th, have your pressure testing done. The second part of the NTO pertained to abandoned flow lines. The other aspect of Firestone is that here's a riser coming out of the ground that at least makes itself available to attach equipment to it. If that is not there, you can't attach any equipment to it. Our current rules, as of 2001, would have required that that abandoned flow line riser be cut off below grade. So our thought was to require operators to go out, find any abandoned flow line riser and mark it so that it's very obvious and make it inoperable by doing a lockout, tagout procedure of some kind. No distance limit. That requirement applies across the state. So that was part 1 or phase 1 of the abandoned flow line part. The second part, now that you've identified them and made them inoperable, is to go back and cut them below grade. So that was the May 30th deadline, identify, mark, tag out, June 30th deadline, cut off below grade. As the process evolved, we did make some modifications, and we also granted some extensions. Most of those modifications and extensions are around the abandoned flow lines that are on an active oil and gas location. So you've got some abandoned lines, but the overall location is still active. Therefore, there are pressure sources, there are lines in use in areas where you might be required to excavate, dig, cut, etc. So there were some requests to back off of the requirement to cut off lines below grade on active locations until those locations themselves are ready to be abandoned and reclaimed. We've essentially granted those requests, provided that the abandoned lines are on the same, the tank and the well are co-located on the same facility, not the remote location that we had in Firestone. So not a situation where the well is here and the production facility that is connected is way over here. Those all have to be cut off. We are giving some leniency on location abandoned lines until such time as that location is ready to be abandoned. So that's kind of where we are in the process. There were some extensions, as I said, granted until July 30th for some operators. We have received a tremendous amount of data. We have something like 250,000 lines of data on the various spreadsheets that operators have submitted. We know that there's a lot of duplication in that data, and I think our biggest challenge going forward is really cleaning up the data and making things all sort of line up nicely. I'll remind everyone that this particular, the NTO, was never intended to be a mapping exercise. We wanted to make sure we had a closed system, that point A and point B are connected and there are no leaks. We did not ask operators to identify the path of the flow line. So if you look at the cord down here on the floor, it snakes across the floor. We don't know the pathway that the flow lines between point A and point B follow, right? That was not part of this exercise. There's kind of ongoing discussion, again, at the governor's office, the executive director's office, about should that pathway of the flow line, should that be mapped? If so, by whom? Where is it housed? Who has access to it? How is it kept current? Those kinds of things. So those are continuing discussions, but that is not something that is going to emerge from this NTO process. With that, I'll just give you some statistical highlights. 176 operators have submitted data to us in response to the NTO. That actually is slightly higher than the number of operators we estimated based on our data had a facility or a well within 1,000 feet of a building unit. So we're feeling good about the sort of compliance by operators in terms of a percentage of compliance. We have received data on 22,963 wells. Again, a larger number than our sort of best estimates, understanding we did not have a complete or precise data set to make that estimate. We do still feel that there are about 1,000 or 1,400 wells out there that we thought were within 1,000 feet of a building that we don't have data on. So that's part of the cleanup too, going back to the operators of those wells and saying, okay, our best information suggests this was within 1,000 feet, but you didn't submit data, why not? And there are lots of potential answers to why not, but we want an answer. So that's part of the cleanup. 22,963 wells on 11,865 locations. That's the number of locations, separate locations that we have data on. We have data on 128,500 risers, flow line risers, 128,573. We have data on 30,582 integrity tests, and we have information showing that 7,568 flow lines were abandoned already through this process. So again, kind of lots of numbers, lots of data, lots of additional work to do to really hone in, clean up, fully understand the picture that we have. And I think that is honestly a months long, not days or weeks long process to really scrub this data. Having said all of that, it's been pretty clear that operators were very committed to this process, devoted a lot of resources to this process. And I think it's been, from what I pick up, sort of water cooler talk, a valuable and I think somewhat eye-opening operation for the operators to realize there are a lot of flow lines out there. There's abandoned flow lines out there. There are a lot of risers out there. I think that has been a little bit of eye-opening to them, and they are taking, I think, as near as we can tell, good measures to respond appropriately to what they find. The last piece of this for us will be on a go-forward basis, kind of if we identify circumstances that don't comply with the NTO, now that those time limits have pretty much run, how do we respond to that? Obviously, there's the opportunity for enforcement, for notices of alleged violation, for warning letters, et cetera. We will deploy those tools as appropriate. I think a clear example is an abandoned flow line that's out there that no one has identified as such, and certainly by now should have not only been identified, but potentially removed, cut off below grade. I think those are actions that we would expect to be taken immediately if we identify those. There are some other parts that one might argue the NTO went beyond our rules in a certain way. So if that flow line that I just referenced had been abandoned before 2001, an operator might argue, well, yes, I know what the NTO said, but your rules don't say that. Your rule didn't take effect until 2001. I don't know. I don't think that's going to be the response of most operators, but it's something I can't rule out. So we are talking internally about some suggested revisions to our flow line rules. My way of thinking about this is that the NTO essentially made that 2011 requirement to cut off lines below grade retroactive, right? I mean, we don't usually do that with rules. They usually are prospective. But here we really want the landscape to look like everything was abandoned after 2001. And one way to get that done would be explicit in a rule change that would say just that you have to cut off those below grade, even though it was abandoned in, prior to 2001. So that's one change we're thinking about on flow lines. Another change we're thinking about on flow lines has to do with the current rules exception for integrity testing for flow lines that operate at less than 15 PSI. We're concerned about the way that rule may have been regarded by operators or implemented by operators, and we think it's worth considering eliminating that exception. Like all good rules, it will take a little thought and some subtlety. There are flow lines that connect to water tanks, for example, where there's not really any meaningful back pressure. So it is sort of a zero pressure scenario. We'll have to think about that. But the return supply line that was at issue in Firestone, our concern is that operators are treating those as low pressure lines when the reality may be otherwise. And that regardless of whether it's greater or lesser than 15 PSI, there's clearly the potential there to result in harm to the environment and beyond if those flow lines are not properly maintained, and integrity testing is part of that. So sneak preview of things that have that I've been in discussions with, again, at the executive director's office and beyond, about potential changes to the flow line rules. And I'll stop there.
Commissioners, comments or questions of staff?
Mr. Chairman, I have a couple questions. I know at the beginning you assigned inspectors to tag along with a lot of these operators. Do you have any kind of estimate as to how many integrity tests we were able to observe? Were we tagging along and escorting operators during integrity testing?
Thank you, Commissioner. Yes, we did. So we assigned field inspection personnel, engineering personnel, and some environmental personnel to sort of just do what you said, tag along with operators, observe their operations, observe these activities. So I'll give you all of those statistics. We have performed 2,200 inspections of wells during the process of operators implementing the NTO. We have participated in inspections at 1,241 locations, and we have witnessed 423 flow line integrity tests. So roughly 10%, which I guess when we started the process, my feeling was we probably wouldn't hit 10% if we tried to just spot check, that we might be closer to 5%. That was the reason to kind of do the embedding. And so even if we're not writing a inspection report, you know, there was a presence there and there was communication there. And I hope that was meaningful in the, you know, in how the process was implemented. But in sheer numbers, those are the numbers of, you know, give or take 10% of the flow lines at wells and at locations.
Right, and we, part of the intent was to try to get an inspector with each operator that potentially had a well within 1,000 feet of a building, right?
I don't think we had enough staff to do it for each operator. I think we aimed at two things: operators with lots of wells, so the Nobles, the Anadarkos, the PDCs, and then sort of the opposite end of the spectrum, operators that probably might not fully appreciate all that was required and, you know, might need some more careful guidance, I guess.
Okay, thanks. Of these 7,000 plus flow lines that were found abandoned, are those abandoned lines that had a riser or point A and no point B?
So I would characterize my understanding of this differently. My understanding is that in this process, an operator made a decision to abandon 7,500 flow lines. And I don't have information for you about why that decision was made. I certainly hope it wasn't that there was no point A and point B. I don't know that. And I don't know that these were ones. Similarly, I don't have any reason to know or believe that they were ones that didn't pass a flow line integrity test. The NTO did not prescribe what operators were supposed to do, but our sort of general rules would prescribe that you have to stop using it, find the leak, fix the leak, that kind of thing.
Right. Okay, thank you.
Further questions or comments?
I have some questions, Mr. Chair.
Sure.
So, and I apologize if you said this and I missed it, but when you talked about there were a certain number of lines that were subjected to a pressure test and then failed. What was the number?
I don't think I do have that number. I said 30,500 pressure tests we have data for.
Okay.
And then the 7,500 abandoned.
Okay, so do we know, or do you know right now whether there were any flow lines where a pressure test was conducted, the test failed, and we found that there were hydrocarbons leaking into soil similar to the situation in Firestone?
No one has reported to us a environmental impact as a result of a leaking flow line under the NTO process, which they would be obligated to do if there was a spill or release under our existing rules. So the rules require a report of a release of 1 barrel or more outside of containment. So there are circumstances where they could have estimated there was less than a barrel and not reported it to us. They would be obliged to respond and clean up the hydrocarbons. Anything 1 barrel or greater, they would be obliged to report to us and clean up the hydrocarbons. And I don't have data on numbers of spills reported.
Is there a deadline for that reporting?
The deadline really would be 24 hours after the spill was identified.
So if there were any that were identified, we should have gotten the report by now.
Should have known by now, if it was a barrel or greater.
Okay. And then I had, you talked more broadly about some possible rule changes that the commission may be considering in the future to address the specific set of circumstances that led to this tragedy. Are there other rule changes that are being discussed at that director level, or is it just limited to these ideas about identifying where the flow lines are and then cutting them off below grade? Or excuse me, cutting them off below grade and then changing the exemption for lines that have under 15 PSI?
Those are the primary flow line rule changes that I have been parts of discussions about. There are other post-Firestone issues, and I don't have a list in front of me. I will find a list on the lunch break, some of which might require rulemaking.
Okay. And I know
one of those, if I may, is the question that we were just discussing, which is sort of orphan wells, distressed operators, how to perhaps address those.
Okay, and I would like to just state for the benefit of my other commissioners so that everybody knows that I share Commissioner Boykin's concern about the distressed operator program and this adequacy of the financial bonding that we have. And so I would be incredibly curious to have more of a conversation with staff about those proposed rulemakings, even though they're in simply the discussion phase right now. So those are the potential changes that might be required to rule. Are there any potential changes to statute that have been identified?
Not directly related to flow lines that I have been part of. So one of the other topics of conversation goes back to the mapping. Whether changes that would require mapping, well, let me put it this way. My own opinion is the commission probably has the authority to require mapping of flow lines by rulemaking. If the commission wants to be the body that has the maps, maintains the maps, provides public access to the maps, et cetera. There's an existing organization, the 811 or One Call organization, that does flow line sort of monitoring, security, identification on a broader scale. So there's been a lot of conversation about integrating flow lines into the 811 system rather than having a separate standalone COGCC flow line system. The 811 path probably isn't a rulemaking for us, although there may be a companion rulemaking to say operators, you have to participate in the 811. That's what we currently do. Our rules currently require operators to participate in 811.
So hold on, can I just ask? Can I just make sure that I understand what that means? So you're saying that under the current rules, operators are required to submit information about the specific location of flow lines to 811?
Not quite, because I don't think that's what 811 requires,
Right.
but our rules require operators to register with 811 and participate in the one call process.
And are there, my understanding is that the other systems that are part of the 811 process, those are not necessarily data sets or maps that are maintained by 811, but that rather there's a sort of a clearinghouse effect where we've got these pipes over here and these wires over here, and there's 811, and they kind of look at all of them, but they don't necessarily maintain or have any sort of enforcement authority to require people to tell them where their stuff is, right?
Generally speaking, what you described is not inconsistent with my understanding as well. But
It was the most lawyery answer.
well, your characterizations were broad and sweeping, so I'm not going to sign up to all of them. 811 has its own issues, and they are aware of them and seeking to address them. So there's a path forward that sees 811 improving its enforcement authority and capabilities that might include mapping data sets, and that, again, we would be requiring operators to participate in that and include their flow lines in that.
Okay.
Anything further?
Mr. Chair, I may be a little confused on this, but if you could speak again to the subject of flow lines abandoned before 2001. So I'm thinking there would be maybe two categories. One would be a flow line that's attached to a well that's still producing or is maybe shut in, but not plugged. And then the second would be a flow line attached to a well that's been plugged. There may be others. So are you saying that the rule, which apparently was promulgated in 2001, doesn't apply to either or both categories of flow lines? That's one question. Another question would be, how do we even know where there might be such flow lines? And are we able to assess whether either of those situations presents an actual risk? For example, you've got a shut-in well, presumably it's not producing any gas, but it could be theoretically, I guess, producing something into a flow line if there's no point B, or if it's not capped. With a well that's been plugged, you like to think that couldn't happen, but so I'm trying to integrate the pre-2001 situation with where we are now. Seems to me if you've got a pre-2001 flow line connected to an existing well that hasn't been plugged, that ought to be covered by the rule. It should be the active well status, even if it's shut in, that controls, rather than when the flow line was abandoned. You might not even know when the flow line was abandoned. So there's a number of questions in there. I'm just trying to understand how the pre-2001 abandoned flow lines fits into all this.
Yeah, I think there's a little apples and oranges, and let me see if I can clarify. So first, an active well, a shut-in well is an active well. So a shut-in well, all flow lines associated with a shut-in well are required to have a pressure test annually. Okay, so that hopefully addresses the category of shut-in wells. An abandoned well, I want to clarify or distinguish an abandoned well between a plugged and abandoned well. So if there's a plugged and abandoned well, there's no pressure source. I'm not going to say 100%, 1000% categorically, never, but there's not anything coming out of the ground associated with that well that you can attach a flow line to and push gas down that flow line into wherever it's going. So plugged and abandoned wells are sort of their own subset. If there was a plugged and abandoned well, and near that plugged and abandoned well, even if the surface equipment had been removed, there was a riser sticking up out of the ground from an old flow line, That's what we're talking about. That needs to go away. That wouldn't have to go away under our rules if the whole thing happened before 2001. We think it should happen now regardless. So that's one of your scenarios. The related scenario is there's a well, it's producing, it has active flow lines, but near that is a flow line riser sticking up out of the ground that's not connected to the well. So I'm going to call that an inactive flow line, even though the well is there and active. All right. I'm also going to call that sort of the worst case of my understanding of the ones you laid out. And it is exactly what happened at Firestone. Give or take, there was an active well, it had active flow lines, they were producing to tanks over here, and now there's this flow line sticking up out of the ground, and something went wrong. Somebody connected something to that. We want those to be gone too. They should be gone under the NTO. That's a flow line that is not active next to an active well. It needs to go away. And it needs to go away even if it's been there since 1946 or whatever date you want to pick before 2001. So I hope we have those different scenarios accounted for. There are lots of variations on that. The only riser sticking up out of the ground that shouldn't be cut off below ground should be one that the operator has identified, so it's clearly marked, and they tell us we are going to bring this back into service soon. I mean, we know it's there, we have a plan for it, we don't want to get rid of it because it is part of future build out would be one scenario. And we have allowed them to tag those, make them inoperable for now, but available for future use. I shouldn't say that, contingent on a successful pressure test at the time they want to bring them back into use. So those are, hopefully that's most of the universe. Yeah.
Anything further?
Yeah, I have one more question that Commissioner Overturf's comment made me think about when you said there have been no reported releases. And I guess I'm looking for some assurance or some level of confidence from staff that operators, when they're finding a point A with no point B or finding flow lines that lack integrity, are they looking at this as, well, this is what I have to do as part of the NTO? Are they considering that there might be a mass of hydrocarbons somewhere? Or are they just abandoning the flow line correctly, like the rules say? Is there any investigation going on or any consideration as to how long gas could have been flowing in that flow line? And are we looking for something that is hard to see and smell and isn't completely obvious all the time, like a liquids release might be?
Okay, all good questions. So your hypothesis, I think pertains to a pretty specific scenario that there is a point A connected to a pressure source and they go to investigate and find no point B. No such scenario has been reported to me. So I don't have a good answer for, did they look at the end of the line? Did they find the end of the line, look at the end of the line and determine that there had been no impacts? I am not aware of that scenario happening. I would say that, just for the record, in Firestone, when they began to excavate the path of the existing flow lines, which is where the abandoned flow line was co-located, it smelled strongly of hydrocarbons. And of course, it was recent and fresh and probably ongoing. So, but I don't want people to have the misimpression that methane, CH4 does not have an odor, but what is getting carried in those flow lines isn't just CH4, and it has odors. But yeah, I don't have a specific answer to the specific question you've asked of, have operators identified that there is no point B scenario, and how have they responded to that?
May I just follow up briefly? I think you responded to there's a point A but no point B, but what about they've just failed, the pressure test has failed? Is that the same answer if we're talking about that category too?
Well, it could be. I mean, if it depends on, to me, it depends on how large of a leak they identified. I mean, I would expect them to identify where that leak is occurring in that line and investigate what was around that leak. I mean, that to me would be their obligation, not to continue to use that flow line to identify the source of the breach, investigate the impacts associated with the source of that breach, and then obviously if they were going to continue using it, to replace the flow line.
I just want to comment that Senator Marble and Representative Sane are operating the Energy Summit meetings. And part of what's coming out of there is the mapping system. So whether it's going to be on 811 or our website, separate website, you know, maybe it ought to be on both. But we're probably going to end up having something from the state on that. The other flow line that I don't think gets enough attention is the house taps. Because part of the leases on some of these farms was that you got a tap to your house. And I think that could be another issue that we may have to end up dealing with at some point.
May I?
Sure.
Plenty of discussions that I've been a part of around domestic taps. Maybe I should stop there.
Nothing else to say.
Well, there's, you know, I will say that I think that area might be best handled at the legislature for a variety of reasons, but, or local governments could consider requirements for domestic taps, but it may be something that you all will get to weigh in.
Well, I think it's something that probably the Oil and Gas Commission should keep track of. I'm not sure how many of them are out there. I mean, some of these leases were done in the 40s, 50s. My lease was done in the 70s. I've got one. So, but we need to know where those are too. And a lot of the operators do know where that is, but it'd be nice if the Oil and Gas Commission had a list of that as well. So in a lot of the 811 stuff, those things are performed by the operators themselves. They call it their own locate crews.
Sure.
So I don't know if 811 is going to be the place to put that map. I mean, it may have to be with us that we require it, but I'm sure that there's going to be something coming out of this Energy Summit along those lines. So it's the only comments I've got. Okay, who wants lunch? We're gonna break for lunch. We'll be back here at, say half an hour? 1:30. 1:30. No, doesn't look like it. Okay, we're gonna start up. Unconventional resource unit presentation. Ms. Jost, Ms. Durante.
Thank you very much. This matter comes before the commission on Jill Durante, hearing officer. This matter comes before the commission on Noble Energy's annual report to the commission on its unconventional resource units for order number 535-300, an approximate 640-acre unit established in March 2013. Order number 535-376, an approximate 1920 unconventional resource unit established in July 2013, and its pooling order 535-485, and an order number 535-635, a pooling order which pooled all interests in a 3,200-acre unit. Noble and its counsel is present to answer any questions regarding its presentation. A copy of the PowerPoint presentation was placed before you at the beginning of this hearing. On behalf of Noble.
This is Jamie Jost with Jost Energy Law, representing Noble Energy, Inc.
Zach Sharon, landman for Noble Energy.
Okay, thank you. Well, thank you for hearing us out today on this annual report. We have 4 unconventional resource unit orders to present to you on, which Mr. Ramsey teed up. We have order number 535-300, 535-376. Both of those are spacings for the original unconventional resource units. We have 535-485 and 535-635, which are both pooling updates. And I'll provide a brief overview of each of the 3 unconventional resource units that we will be discussing today. If you look on slide 3 of your presentation, these are the 3 unconventional resource units. You can see that one in blue is a 640-acre unit. The one in red is a 1,920-acre unconventional resource unit, and the one in green is a 3,200-acre unconventional resource unit. I'm going to start with the one in blue. This is the unconventional resource unit that was approved on March 25th, 2013. It's a 640-acre unconventional resource unit for the development and operation of the Codell and Niobrara formations, not foundations. Any vertical and directional wells were excluded from the new unconventional resource unit, and when developed, there was one existing horizontal well when the URU was approved. This unit has 600-foot setbacks from both the Codell and Niobrara. Those are subsurface setbacks, and 150-foot inner well setbacks between horizontal well borers. The order allowed the appropriate number of wells to effectively and efficiently drain the reservoir to be developed. So the unconventional resource unit order did not set a number of wells. It allowed the operator to set the number of wells for the efficient and economic development of that unit. There were 9 new horizontal wells drilled within the unconventional resource unit. Drilling began in December of 2013. Completions were in February of 2014, and production occurred in March of 2014. This unconventional resource unit is one of the longest producing unconventional resource units at this point, with 3.5 years of production under its belt at this point in time. When the unconventional resource unit was established, there was a unit agreement and a unit operating agreement that were sent out to the working interest owners and unleased mineral interest owners prior to the approval of that unit. And those unit agreement and unit operating agreements are in place. If there were any issues to really come up with respect to the operation and development of that URU, those would mainly be governed by contractual rights under the unit operating agreement. Noble is designated operator under the unit agreement and unit operating agreement, as it owns more than 93.75% leasehold in this URU. The URU does utilize central facilities to minimize surface impact, and pipelines are utilized in this area. For purposes of this URU, Noble does believe that this URU is fully developed. There's several reasons for this. One, this was one of the first URUs to be approved in October of 2013, almost 4 years ago, with production starting in March of 2014, so over 3 years ago. We have reported on this URU before on the 640-acre basis. We recognize there have been some questions with respect to the lack of wells in the west half of this section.
As you can see on this exhibit, the brown square are federal minerals. And at the time the URU was put in place, those were unleased minerals. The development occurred, production began in March of 2014. The lease actually did not occur until 2015 of these minerals, once Noble had already developed this acreage. And so that the BLM acreage is one of the reasons that that western portion of that URU has not been developed. If there were any concerns with that development, both the BLM and then the other working interest owner, which is Juliander Energy, could have brought forth concerns with respect to the not having wells located within that area. They have not, and we have never received any concerns with respect to the overall development and production on this URU. With respect to the second URU we're reporting on, this is the URU in red. This is order number 535-376 that approved the 1,920 acre unconventional resource unit in July 29th specifically of 2013. This was also to the Codell and Niobrara formations. Vertical and directional wells were excluded from the URU. Those remain paid as the original allocated basis in their underlying units. There were 3 existing horizontal wells when this URU was approved. And those wells have been included in this unit. There's 600-foot setbacks again. This is again our subsurface setbacks with respect to the development and operation of the Codell and Niobrara formations with 150-foot interwell setbacks. This URU also allowed Noble to drill and develop the appropriate number of wells to efficiently and effectively drain the reservoir. In this URU, Noble placed 41 new horizontal wells. They were drilled in October of 2014. Completions began in January 2015 and production occurred in March of 2015. Again, the same thing that we had with the 640 acre URU. We have a unit agreement and unit operating agreement in place for the working interest owners and unleased mineral interest owners. Noble is the designated operator and holds approximately 93% leasehold in this unit. The URU does utilize centralized facilities for purposes of minimizing surface impact, and pipelines are also utilized in this area. Let me go back for just a second. We are also providing an annual update on order number 535-485, which pooled the 1,920 acre URU here. That was approved in April 28th of 2014. Again, unit agreement, unit operating agreement were in place. At the time of pooling, over 80% of the working interest owners had actually signed the unit agreement and unit operating agreement. All working interest owners and unleased mineral interest owners did receive election letters. AFEs, if they were unleased, they received offers to lease. And that had passed well before the hearing date and the approval on April 28th, 2014. Again, Noble's the designated operator, and this pooling actually went through on an unprotested basis in 2014.
Good question.
Of course.
Should there be a red line for each well there to get to 41 wells?
So that would be a representation of the 41 wells. So technically, yes. And I just want to make sure I have my numbers right. Yeah, there should be approximately 41 wells in there.
So 33 or
40. And some, I mean, if they're to the Codell or Niobrara, they may be represented as underneath some of the lines as well on the map itself, because we do have 2 different formations that are producing from that URU. Okay. Thank you, Commissioner. Okay, and then the next annual update is for order number 535-635. This was a pooling update because we did report on the spacing of the unconventional resource unit in December of 2016. So just a quick reminder as to the spacing of the initial unconventional resource unit. This was a 3,200 acre unit that was also approved on April 28th, 2014 to the Codell and Niobrara formations. This unit actually has 38 new horizontal wells that were drilled in April of 2015, completed in July of 2015, and started production in August of 2015. There is a unit agreement and a unit operating agreement in place for this URU as well. And Noble owns approximately 92% of the leasehold. As you can see, Noble has utilized central facilities to also minimize surface impact, and pipelines are utilized in the area as well. And then for purposes of the pooling that applies to this, we have the same aspects that apply to the URU I just discussed. The unit agreement and unit operating agreement were in place prior to the approval of the URU. Noble was the designated operator. At the time of pooling, over 80% of the working interest owners had signed the unit agreement and unit operating agreement. All interest owners did receive the election letters, AFEs, and if necessary, offers to lease for purposes of unleased mineral interest owners prior to the hearing date. And this also went through as an unprotested pooling. So basically, that is our, oh yes, sir.
Can we go back to the very first one?
Sure.
You're talking about the west half of the west half of 15?
Yes.
What is that, 40 acres that the bed's on?
Yes.
Yes.
Who owns the minerals above and below that?
Noble owns the leasehold above and below that.
Drill the west half of the west half?
And Zach, please correct me if I'm wrong, but I don't believe Noble has any plans currently to go back in and drill that because they would have wanted to do it during the actual initial development and drilling of the URU in 2014.
Seems like you're leaving some unexploited minerals there.
Well, and from Noble's perspective, I mean, there is a recognition that that could likely occur at the approval of the URU because it was unleased mineral interest, BLM mineral interest at that point in time. Zach and I actually did have a conversation, several conversations with the BLM about the unconventional resource unit and the development. And they meaning the BLM, understood that that would be a possibility, that those minerals wouldn't be developed, as did the other, and I would say the other one, working interest owner within the unit at that point in time.
And do you have the mineral lease on that BLM property now?
Noble does hold the leasehold, yes.
And the BLM isn't requiring it to be drilled?
Not at this point in time.
Chairman? Can I ask a question? Sure. I just had a question about, well, were the federal minerals or BLM receiving royalty from production throughout the section? I mean,
It was requested in their communitization agreement that it was held in escrow until the lease was issued, and then the revenue was dispersed.
Okay, so, but at least we know that would probably satisfy their requirement that the lease be developed. They may say it still requires more development, but that would be something you would handle in the future if it came up.
Yes.
Exactly. Specifically, as because this URU is also governed by a communitization agreement with the BLM. Yes.
The whole URU?
Yes. Yes, sir.
So there wasn't otherwise, I'm sorry, Mr. Chairman, there wasn't otherwise any pooling as such. It's the CA that accomplished that?
The CA accomplished it for purposes of the federal standpoint, but there was a pooling associated with this URU as well.
There was a pooling.
Yes, sir.
It would be helpful for me.
Okay. And actually, I think I misspoke. I was thinking of our other URU. We have a 3,200 acre URU next to it. I think that was the pooling we were discussing, or I was thinking we did, but apparently we did not do a pooling for this one because we have a communitization agreement with the feds. Yes.
Right. So since I'm new to the commission and wasn't here when this all came about, it might be helpful if you gave us a quick overview of what is a URU and why are you here today?
Absolutely, I'd be happy to. So an unconventional resource unit was an idea that came up in maybe early to mid 2013. Interim Director Tom Kerr was here at that point in time. I believe Director Lepore was here at that point in time as well. To basically allow the development of hydrocarbons on a larger basis and allowing the, I say larger basis because the 640 is the smallest URU we have in the state. Most of the other unconventional resource units range from, we had some 1,280 acre units to the large 3,200 acre unit. And basically what the unconventional resource unit was brought into play was to allow an operator to put forth a unit agreement and a unit operating agreement, one to designate operatorship for purposes of taking the development risk to develop these very large units on a basis that was governed by a contractual basis, but also utilize that contractual basis to have the commission approve these larger units. Because before we had these URUs, we really didn't have too many large scale drilling and spacing units, I would say, in place in the state.
When you say large, you mean more than one well, or?
I would say more than approximately 1,280 acre unit. We had a couple 2560s over on the western slope, meaning 2560 drilling and spacing units. And those are not governed by any joint operating agreement or anything along those lines. And it was this idea that came forth is basically to allow an operator to develop a larger amount of acreage as approved by the commission with a unit agreement and joint operating agreement in place between the parties. Not saying that they couldn't do that otherwise, but this was kind of the term that was utilized at that point in time in 2013 to allow this larger scale development. One of the other reasons that the URUs and Noble situations were approved, and we had so many of them, is because Noble had a very, I don't know if quick is the right word, but a very accelerated drilling program for these URUs. And so once the URUs were approved, Noble was able to go in and just conduct its drilling of the entire unit at once, instead of having to come in, go back, come in, and go back. So that was the general basis for the URUs.
Was there any kind of a drilling requirement or commitment? Did Noble commit to some number of wells or to a concept of developing the unit, or what?
No, there was no drilling obligation or drilling commitment. When we presented these to the commission, I believe it was, well, the initial ones were in October of 2013, and they were over in Lyman, where the hearing was. We went in knowing the drilling schedule, and so we were able to tell the commission they're going to be drilling on, like we've already presented, in July of 2013 with anticipated production by X date. But none of that related into a drilling obligation. That was voluntary information that the operator, as with Noble, decided to put forth to the commission.
So there's no actual requirement in the order or regulation or any other document that requires some number of wells, or that all the acreage be developed, or what?
Not in the orders. Oh, do you want to go ahead?
No, I was just going to indicate that there's no specific requirement of a number of wells. However, we did require that it would be according to the commission and the staff's position whether the units were fully developed. And once those units were deemed fully developed by the commission and by staff, then at that point the requirement in the order that the operator no longer be present annually would then be waived, or would then stop. But it would be based on whether or not, as the commissioners, you determined that the units were fully developed.
So I assume you're going to make a recommendation to us.
Well, there is, following this, the request on docket number 1703-00129, which is their request for a variance. Our position is going to be clear in the variance as to whether or not we believe that the variance should be approved as to these units. So I was going to wait until the second portion of this presentation by Noble.
Well, this is helpful because I didn't know what you were requesting a variance from.
Okay, thank you. Yes, and we were told from our standpoint from the hearing officer that we needed to give the annual report first.
Sure.
And then ask for the variance with what we were asking second, so we could walk through the procedural requirements of ensuring the annual report. Oh, no worries. Thank you.
Well, excuse me, but is part of what we're here for today is to say this has been fully developed?
What we'll be asking in the variance request is that we're requesting a variance from the annual reporting requirements on all of the URUs.
I understand that, but
right.
This specifically, are you telling us it's fully developed?
Noble's position is that this full order 535-300 is fully developed at this point in time for the reasons we've specifically presented to you here. We recognize that there is some area over there, but for purposes of the development itself, I guess fully developed could mean a lot of things. And from our standpoint, we, do believe that it is fully developed for purposes of the efficient and economic production and development that has occurred up to this point and moving forward.
We're jumping ahead of case, right? Let's go ahead and finish off this case. I don't think we make any decisions on this. There's no motions or any votes or anything that's going to take place on this one, right?
Correct, not on the annual report.
Finish this one up and then get to the 170300129 and then we can ask all these questions.
Excellent, thank you. So basically to conclude, Noble's plan development of each of the URUs was presented to the commission during each URU hearing and prior annual reports. We have reported on each of these URUs to you on a variety of occasions. I should say some of you, not all of you. Noble did carry through on the plan development that was proposed at the hearings on the URUs, and we have presented annual reports at prior commission hearings. We would respectfully request that the commission treat this annual report on each of the URUs discussed today as the final report on the URUs, and then we'll address the rest in the variance request here in just a second. Thank you.
So we don't take any action on this.
That's correct.
Okay, let's move on to the next one.
Thank you. Docket number 170300129 comes before the commission, followed by Noble Energy for a request for an order to approve a 502B variance from the orders requiring it to present annually to the commission on its unconventional resource units. The underlying orders require Noble to present on all of these units annually unless an exception is granted by the commission. Order numbers 535-300, 535-302, 535-376, 535-435, 535-451, 535-480, 535-485, and 535-635 are a combination of pooling and spacing orders. Staff has reviewed the development of all of these units and has discussed these URUs with Noble. And at this time, staff recommends approval on all of the orders with the exception of 535-300, the one you previously discussed, the approximate 640-acre unit. We do not believe that that unit is deemed fully developed according to staff's position. After Noble's presentation, Jane Stanzik, the permitting and technical services manager, and I will be prepared to explain our position to you with respect to whether that 640-acre unit is fully developed. On behalf of Noble.
Thank you. Again, my name is Jamie Jost on behalf of Noble Energy, and I do have Zach Sheeran with me from Noble Energy from the Land Department. All right, thank you. Well, we are here now on a request for a variance to the annual reporting requirements on each of the URUs held by Noble within the state of Colorado. Mr. Yancey did walk through each of the dockets, so I will not walk through each of those again. But the reason we are here is twofold. In December of 2016, Zach and I presented URU updates on order numbers 535-302, 435, 451, and 480. At that point in time, we also made the request to have the annual report requirements waived, or in this instance, a variance allowed for these requirements because we believe these URUs are fully developed. That's why we are back here, number one, because during the commissioners' deliberations and discussions on the annual report, they did agree on record that that was a good idea and that we had to procedurally ask for it in an appropriate manner. So the manner that they told Noble and I believe staff to have this go through would have been the variance request, which is why we're here now. And so that is our first reason, is that we are back because at the December commission hearing, we were told this was the way to do it. Secondly, we have presented to this commission on various occasions, and we have presented the URUs are fully developed and that the remaining annual reports will not contain any new information. The production is occurring and is being maintained within each of these URUs. There are no plans for additional development of these URUs at this point in time. And we would just like to have the commission allow a variance to those annual reporting requirements. So in your handout, this is a very simple handout, but if you will turn to what's page 4, which is the map of all of Noble's URUs, you can see how the field has been developed on an unconventional resource basis. This is a summary of each of the URUs presented to the commission since October of 2013. Moving forward to our annual report we did in December 2016 and to the annual report we just did today. So each of these URUs, again, are fully developed, and they are subject to Noble's variance requests in this matter. And as such, we would basically just respectfully request that this commission grant a variance to Noble for the allowance of no more annual reports on each of the URUs in Colorado because they have been fully developed. Thank you. Including 300, yes, sir. Thank you.
Have we heard the staff report, all the staff report?
Yes, so with respect to 535, 300, first let me back up. With respect to all of the other URUs, 376, 480, 302, and 451, staff is in agreement with and recommends approval of the 502B variance. With respect to 535, 300, as indicated, it is a 640-acre unit. 25% of that unit has not yet been drilled, has not yet been developed. It's our position that without the development of that 25%, it would result in waste. And at this time, we would request that Noble continue to present to the commissioners on its planned development on that 25%. And we believe that that annual report would present as an impetus for it to develop that acreage. And we would ask that the variance on 535, 300 be denied.
Questions or comments?
I have a question. So what would be the consequence if we deny the variance, then what happens? They just have to come tell us every year, well, we didn't drill it this year.
Unfortunately, Commissioner Boygan, in our original order, we did not have any set consequence if Noble did not develop that acreage. It's our hope that through our discussions with the BLM, as well as with Noble, that that will prod them in some way to develop that acreage. But at this time, the only basis to stop the annual reporting to the commissioners would be if that unit were fully developed. And if we recommend approval on 535, 300, it would be as if we considered that unit fully developed, and we do not. And so as such, we believe that we have a responsibility at this time to recommend denial of that one until we see further action and further development on that unit.
So that was a communitized section?
Correct.
So did the BLM participate in the whole 640 acres?
Yes, Commissioner.
There? Yet they weren't even drilled.
Correct.
Yeah, that doesn't seem equitable to me. It's 160 acres total, 40 of which are feds that aren't drilled.
Well, and from the standpoint, if I may, we have not had any, well, the other working interest owner is a smaller working interest owner. And I believe that, because we did not have to pool this, they are a working interest owner that would be participating in this. We have not had any instances where the working interest owner or the BLM has stated they don't deem this fully developed and have not requested any other wells, which they could do so under a unit operating agreement.
What about the other mineral right owners?
Mm-hmm. And from that aspect of it, the mineral right owners, I guess 90+% are held, leasehold is held by Noble, and Noble does have a duty to act as a reasonably prudent operator under its leases in that. And those mineral right owners are receiving the allocation of production and proceeds from this unit on the 9 wells, just like they would from additional wells if they would have been drilled. So we also haven't had any instances where mineral interest owners have come to us with concerns as well. Thank you.
Mr. Chairman.
Thanks.
Let's say just for the sake of argument, that all of the other orders were granted the variance, this one was not granted a variance. And you had to come back every year and report. Do the other owners, both royalty and working interest, get notice of this annual report? Do they get copies of the annual report, or?
The annual report gets set by the commission hearing staff, and so it would be on the docket rather than a notice of hearing. But in this specific instance, the variance request did go out to the working interest owners and unleased mineral interest owners, actually quite a few months ago, and we have not had any protests to this matter. Yes.
And under the unit agreement, or you don't have a unit agreement, so
In this one,
you
we
have a
have a
communitization,
CA.
but no operating agreement of sorts.
We actually had a unit operating agreement that was sent out to the other interest owner, which I believe was Julander Energy.
Okay.
Yes.
All right, thank you.
Further questions or comments?
I do have one question. I'm trying to get it straight, if the variance is granted, then that means that there's no more annual reporting and that you don't have to move forward with providing us with updates. If the variance is granted and then at some point you determine that, or the group of you determine that you do want to engage or drill additional wells, would you need to come back for additional commission approval, or would you simply unvariant?
So with these, if there's any new develop within any of these units after the request for the variance is granted, then we would request that Noble, we would obviously be aware of it because they would have to go through the permitting process. And we, once the development would begin, we would ask that that they start to present to the commissioners again annually until that development is finished.
Okay, and I want to just make sure that I understand that you've got a variety of different owners that have an interest in number 300, and none of them, they are all in agreement or at least do not object to Noble's characterization of this parcel as fully developed.
Correct. Correct. Absolutely. That would have, if they would have protested or had an objection, they, one, could have come to Noble directly. They do have good working relationships with their interest owners in the unit, or they could have protested the variance request that was sent out pursuant to the notice procedures of the commission prior to this hearing as well. Thank you.
Although I understood Mr. Hansi to say that they would be in communication with the BLM to talk about the potential for further development.
Certainly, at this point, obviously BLM did receive notice of the variance. However, they had not communicated with us with respect to whether they would prefer additional development within this area. But because it's such a significant portion, it's such a significant percentage of the unit, we would like to follow up with them and discuss with them whether or not they would deem this fully developed and whether or not they take a position on whether or not this annual reporting should continue.
Okay, so it looks like we got two choices. We can either approve the staff's recommendations and pull out 535-300, and so that they have to come in for further presentation, or we can approve Noble's request and include 535-300.
You're right.
So the chair is looking for a motion.
I would make a motion that we accept staff's, or that we accept staff's recommendation.
Which would pull out 535-300.
Yes.
Okay.
I second.
Motion by Jolly, second by Ayer. All in favor?
Do you want to have any more discussion?
You?
Well, I guess I don't see that it's, other than an obligation on the Noble to have to come back and take up, you know, presentation, send some paper and tell us what they're doing. Regardless, I don't see that there's a lot of downside or upside to approving even the 640. We're not in control of the development. We're not going to shrink the unit and cut out the BLM because they're getting a share of the revenues right now and they're happy, apparently, it seems. So I just don't see that there's a significant issue whether, you know, to have them continue to come back. And I'm trying to understand what would our action be if no more wells ever got drilled there? We're going to shrink the unit up and cut the west half out? I don't think so. So I don't.
What's your suggestion?
My suggestion is to just grant the, it appears to be substantially developed, maybe not fully developed. And there appears to be no objection from any of the royalty or working interest owners to that. And all of the parties involved are currently receiving revenues. I'm inclined to, let it be approved. I just don't see the downside to it.
Noble's request.
Yes.
Okay, further comment?
I completely agree.
I can say the reason I disagree is that I agree with what you're saying as to the effect to this case in particular, but I don't like defining that as developed in a general sense and setting that precedent for other potential URUs.
Anything further? Looks like I need a roll call vote.
Yes.
Okay, call for a roll call vote. Call for the question.
Commissioner Hawkins.
No.
I
Commissioner
think,
Boygan.
hold on.
Yeah.
It's yes on the variance.
Well, but the motion right
Oh,
now
sorry.
is to approve all except 300. And just to clarify,
I see, thank you.
I would just grant approval for all of the units. So on the motion that's on the table, I guess I vote no.
Perfect, thank you.
Just to be clear, if we vote, if this doesn't pass, then we take another vote to accept that it is all approved.
Maybe. Gotta do something.
I mean, that would be the second step.
So everybody understands the motion, right? Okay, continue.
Okay, Commissioner Boygan,
I vote aye on the motion.
Commissioner Jolly,
Yes.
Commissioner Holden,
Yes.
Commissioner Overturf,
No.
Commissioner Aker.
Yes.
Like the yeses have it 4-2.
So everything is included except for 535-300.
That's correct.
Okay. Next case.
Thank you. So they'll be reporting in a year from today.
Oh, yeah, no, and I understand what they're concerned, they're just. It's not so. Kind of what I thought, like a through the motion.
Mr. Russ, are you keeping time on this?
I am. Theoretically speaking.
He's stealing time from staff. They're like,
And I still see anything happening.
You can go ahead and sit over there.
Well, I mean, I can understand. I certainly don't disagree with what they're proposing.
on this one? Okay.
Because it's not fully.
Okay, before we get started, Commissioner Jolly has something that he would like to discuss.
I'd just like to disclose, I have had a legal dispute with Bill Barrett in the last 2 years. It's been peacefully resolved. I don't have a conflict here. I intend to participate, but I just wanted to bring that forward for the commissioners.
Any of the commissioners got a problem with that? Disclosure? No? Okay. Ms. Jost,
Okay, may I have 2 minutes, please?
who are we going to? Mr. Rancy?
Yes. He is ready to roll. That's awesome. Thank you. What? Good afternoon. My name is Jill DeRancy. I'm the hearing officer for this matter. Will the parties present please identify themselves first? Good afternoon again. My name is Jamie Jost of Jost Energy Law here on behalf of Bill Barrett Corporation.
Ken Wanstone, Senior Vice President, General Counsel, Bill Barrett Corporation, here as its attorney and co-counsel with Ms. Jost.
And on behalf of the protestant?
Lee Moorhead on behalf of YMC Royalty Company, LP.
Thank you. Docket number 1707-00432 comes before the commission filed by Bill Barrett Corporation for an order to amend order number 407-871, which pooled all interests within a unit. Bill Barrett Corporation requests that the commission delete the first sentence of paragraph 3 in order number 407871. YMC Royalty filed a protest to the application. No hearing officer recommendation was provided to the commission. An order of presentation was provided in your portfolios. The parties have been allocated 20 minutes each for their legal arguments, and we'll begin with Bill Barrett today at this time.
Thank you, and we would like to reserve 5 minutes for rebuttal for whoever is keeping time. Great, thank you very much.
Before we start, can I just ask a matter of procedure? Are we allowed to ask questions while they present, or do we save up and ask at the end? Obviously, if we ask in the middle, their 20 minutes will be impacted.
We usually take that into consideration. Normally, if you can, wait till the end. It makes it easier.
All right, that's fine.
But the 20 minutes is exclusive of commissioner questions.
Yeah. And response.
But then he'd have to keep track of.
Yes, he's
Yeah,
good.
I plan on pushing the button. We'll see how this system works.
Okay, I'll try to restrain myself.
And just for clarification, we would not be opposed to questions during, if you like. Okay. So, all right, thank you. Mr. Yancey did pass around a hard copy of the PowerPoint that we have up as well. This application is very straightforward. BBC's request is very simple. We are asking that one amendment to the language of a prior order, an October 28th, 2013 pooling order, order number 407871, be amended, modified, or repealed, utilizing language already existing in that order. Specifically, it contains language that does not accurately reflect the Oil and Gas Conservation Act statute, section 3460.116.7a. Specifically, BBC is requesting that the commission amend the order to strike the first sentence of the order section, paragraph 4, which I'll get to here in a second, and issue a new order retroactive to the original application date with that language struck. The legal issue from our perspective is very simple. Should the commission delete the inaccurate language in order number 407871? The answer is yes. The commission should delete that language, and it can delete that language. Specifically, order number 407871, and I will say this is exhibit 2 in your BBC exhibit that would have been submitted, I believe, to the commission with the portfolio. Can we confirm? And if not, I do have extra copies if you would like one.
I'd like one if I could.
Okay, great. They did receive the pre-hearing statement as well as this. I won't get out.
No.
Okay.
Specifically, in order number 407871 on page 3, there is express language that states that the commission expressly reserves its right, after notice and hearing, to alter, amend, or repeal any or all of the above orders. And order number 407871, order paragraph 7, and I keep saying order because there is the findings section and the order section with different numbers of paragraphs. And so just to point you to the right place. Also expressly states that nothing in this order is intended to conflict with 3460.116, as any conflict that may arise shall be resolved in favor of the statute. The summary of the underlying order that we're here for, this is order number 407871, was a very straightforward pooling order that was issued on basically in October of 2013, that pooled all interest in a 640-acre drilling and spacing unit established for Section 20, Township 6 North, Range 61 West. And it was to accommodate the Greasewood 10-20H well for the development and operation of the Niobrara Formation, effective as of the earlier of the date of the application or the date that any of the costs specified in CRS 3460.116.7B2 are first incurred for the drilling of the Greasewood 10-20H well for the development and operation of the Niobrara Formation. The protestant or its predecessors in interest did receive notice of this pooling application and did not protest this pooling application and did not appeal this pooling application. Order number 407871, if all of you now have these in front of you for Exhibit 2, if you will turn to page 3 of the order, paragraph 4. This is the language that we are asking to strike. Paragraph 4 states in error, any unleased owners are hereby deemed to have elected not to participate and shall therefore be deemed to be non-consenting as to the well and subject to the penalties provided by 3460-116-7. Any party seeking cost recovery provisions of 3460-116-7 shall first comply with subsection D for any subsequent wells. We are asking for the first sentence of that to be stricken from the order, as it is basically it does not reflect CRS 3460-116-7A. The concern is with the use of the term any unleased owner and hereby deemed to have elected not to participate. In many instances, there are unleased owners that do participate, and what this order does is the language itself states differently. There is also language in the order, if you look at page 3, paragraph 7, that says nothing in this order is intended to conflict with 3460-116 CRS as amended. Any conflict that may arise shall be resolved in favor of the statute. And on the slide I have up on the screen, this is the statute that language is referring to. CRS 3460-116-7A provides that, except as provided in paragraph C of the subsection 7, as to each non-consenting owner who refuses to bear his proportionate share of the cost and risk of drilling and operating of the well, the order shall provide for reimbursement of consenting owners who pay for the drilling and operation of the well out of the non-consenting owner's share of the costs and risks of such drilling and operating out of and only out of production from the unit representing his interests, excluding royalty or other interests not obligated to pay any part of the cost thereof. We are just concerned with the bold portion in that statute, because what that does is this statute contemplates that both unleased owners, unleased non-consenting owners unleased owners can be consenting or non-consenting. This statute states that basically the penalties apply to non-consenting owners who refuse to bear their proportionate share. We have many instances, including in this instance, where an unleased interest owner agrees to pay its proportionate share. And so therefore, if that agreement to pay its proportionate share is in place, then the language in paragraph 4 that says any unleased owners are hereby deemed to have elected not to participate actually is not accurate, because we do have unleased interest owners that have elected to participate, and that language would be incorrect as to the application to their interest, as well as really not in line with the statute. And I have already hit on this, but again, the order contemplates situations such as this, that if there is language that is inaccurate in the order, another portion of the order expressly states that any conflict shall be resolved in favor of the statute. And so in this instance, with respect to YMC, who is basically stating that they will have relied upon that inaccurate language in the order, basically the argument becomes irrelevant, because the language in the order also states that any conflict shall be resolved in favor of the statute. And the statute only mandates that cost recovery penalties be applied to those non-consenting owners who have failed or refused to bear their proportionate share of the cost. Here, they did elect to bear their share of costs. So, and also to support the argument that you should amend the order, your own order, order number 407871, gives you the ability to do so. The language specifically says that the commission expressly reserves its right, after notice of hearing, which we have today, to alter, amend, or repeal any or all of the above orders, referencing the above orders in the actual order itself on page 3. So this is clear authority that the commission can and should delete the inaccurate language of this order. So to the extent that YMC will present its argument, it is Bill Barrett's perspective and position that the protest is actually irrelevant in light of the express language of the order, as well as the applicability of the statute 3460-116-7A. We believe it's irrelevant for several reasons. One, because the language itself in the order kind of fixes the situation by falling back to the statute. But YMC's protest is irrelevant because YMC participated in the Greasewood well, covered by the pooling order as of March 15th, 2016. In your hearing packets, and I do have another copy if you would like it, it's our Exhibit 6 that would have been attached to the pre-hearing statement, is a copy of YMC's election letter. That election letter was signed even prior to the date the application for the original order was filed. Additionally, which is our Exhibit 6, BBC's Exhibit 6, YMC signed a declaration of pooling on March 29th, 2013. That also basically evidenced their election and participation in these wells. So really, regardless of whether that language is in the order or not, YMC is a participating party and would not have had any cost recovery penalties applied to it by virtue of this order due to its election to bear its proportionate share of the cost under Section 3460-116-7. And basically, as you listen to YMC's legal argument today that was set forth in their protest as well as their pre-hearing statements, we do believe that this is a very specific last-ditch attempt to confuse the commission with a hindsight argument that was brought up by counsel very late in a litigation that's pending in front of the U.S. District Court currently. And we can discuss that litigation a little bit more, but we don't really believe that it's relevant to the hearing here today. By virtue of the YMC's protest, we believe that they're trying to misapply the law to YMC's interest, as they do ignore the application of CRS 3460-116-7A as it applies to a participating interest owner. By virtue of its filings with the pre-hearing statement, there's been an attempt to introduce irrelevant and inaccurate factual statements into this hearing as an effort to build a record that they can be utilized in the U.S. District Court litigation between the parties. An example of this is both the protest and arguments made in the pre-hearing statement. They did submit affidavits, which are hearsay from a Texas attorney, from witnesses in violation of the commission hearing officer's mandate that no witnesses be presented during this hearing, that it would just be a legal argument. And basically that they're trying to rely on an incorrect statement of law in order number 407871, when the order paragraph number 7 specifically states that the law in the statute trumps the language of the order. Additionally, YMC will not only attempt to raise issues well outside the scope of COGCC's jurisdiction, these are contractual and title-related issues as set forth in its protest and pre-hearing statement, but it's also argued that it will attempt to preclude you, under the guise of equitable estoppel, from actually acting on the very order at issue. This is not a question concerning any of the open litigation issues set forth in YMC's protest. This is not a contractual issue. This is not a matter of equitable estoppel. It is only a matter of whether the COGCC should amend Order 407871, which in BBC's view is a yes, as the Commission retains jurisdiction over all aspects in connection with that order, which is stated verbatim in the order, and is expressly allowed to make amendments. The COGCC has recognized that this prior pooling language is inaccurate because the Commission is incorporating new corrected language into all of the statutory pooling orders that were issued at this July hearing, all of the ones on the consent agenda. And the COGCC, you as the commissioners, must understand that as YMC's arguments as presented today are irrelevant and they are not at issue in this application. The only issue presented to this commission today is whether the commission should strike the first sentence of the order paragraph number 4. Nothing else. Thank you very much for your time.
Okay, she got 5 minutes left or 3?
6 minutes and 50 seconds, actually.
Go ahead.
Thank you, sir. And also just want to say thank you to the commissioners for hearing YMC's protest today. I don't have a representative of YMC Royalty Company here, but on their behalf, we just want to say thank you for the opportunity. I would agree with Ms. Jones that at first blush, Bill Barrett Corporation's application or request to eliminate just that one sentence in paragraph 4 seems innocent enough. But as Ms. Jost explains, Bill Barrett Corporation wants to eliminate that sentence so the order better reflects CRS 346116. But order number 407871 in its current form accurately reflects the statute. And so no amendment is needed. As even Ms. Jost says, the amendment's irrelevant because the order says the statute controls. So why is there a need to make the amendment in the first place? Just let the statute speak for itself. And with that, it is on Bill Barrett Corporation to prove to the commission that the order requires amendment. And I think Ms. Jost has just explained why the order doesn't need amendment at all. But let's say there is, and I think that also goes now towards that the way it is, the way the order is currently is an accurate reflection of 346116. So basically what happens is in 346116 is the commission then orders anybody who hasn't signed a lease or any kind of a joint operating agreement, they're involuntarily pooled and subject to 346116. In fact, the 346116 doesn't even, if you look at all the slides, doesn't even say the words electing to participate. So it's kind of, we're talking about two separate things. And so what the problem is with, and why the order as it stands is okay with 346116 is because if somebody doesn't have an agreement, a mineral owner doesn't have an agreement with the operator, whether that be through a joint operating agreement or a lease agreement, then they're an unleased mineral owner and they're deemed not to consent. And so they're a non-consenting owner. And then if they want to change that order, change their status from 407871 as being a non-consenting owner, they're free to agree with the operator. They can go into a joint operating agreement, they can go into a lease. But that never happened in this case. And so that's why the order is okay under 346116. And I'll get to explaining that a little bit more later on in my presentation. But Ms. Jost hinted at the underlying lawsuit between Bill Barrett Corporation and YMC Royalty. And so just so the commissioners can have some context as to why there's an application and why there's a protest, I just want to briefly go through the facts of that lawsuit. So Bill Barrett Corporation brought suit against YMC Royalty Company in June 2015 and against others as well, alleging that YMC promised to pay part of the cost for the Greasewood 1020H well. The case is pending in the United States District Court for the District of Colorado before Judge Brooke Jackson. Now, in that lawsuit, Bill Barrett Corporation alleges that the election letter that Ms. Jost referenced and the AFE that YMC Royalty Company did sign are enforceable contracts. But what we've argued in the district court is that they're not enforceable contracts as a matter of law. What contracts we see in the industry are joint operating agreements. They're long, 90 pages sometimes plus, not these 3-paragraph election letters that are now going to dictate the cost for $5 to $7 million wells. And so that's the typical process. And so in the alternative, what Bill Barrett Corporation is alleged in that lawsuit is that YMC, among others, were unjustly enriched. Now, you can't, under law, you can't be unjustly enriched if there's an adequate legal remedy. And so on summary judgment to the district court, YMC argued, among other things, that there is an adequate legal remedy, 346116, just as order 407871 says, that's where you get to go Bill Barrett Corporation. You don't get to just sue YMC. You get to take our production and use it to offset costs to the tune of 200 times the intangible cost. So it's not like they're left with nothing here. They get up to 200% of their intangible costs. And so, and that argument was then finalized at the U.S. District Court in 2016. Order 407871 has now been on the books for almost 4 years now. So why is Bill Barrett Corporation just now moving to amend this order that is so clearly not reflective of 346116? It's because it's an argument for YMC in the underlying civil lawsuit. And so that's why YMC is protesting. Because not only did YMC, when order 407871 came down, YMC relied on that order. And this gets us into the first reason why, or it gets us into the equitable estoppel argument to a certain degree. It's not a red herring or irrelevant. What we're arguing here, what YMC Royalty is arguing, is that it relied on order 407871 and that the commission should not now, some 4 years later, change that order. So when YMC elected to participate, the letter, as Ms. Joseph has shown you, says if you elect to participate, we'll send you a joint operating agreement. So in YMC's mind, okay, there was no information about the Greasewood well at this time out there. This is in March of 2013. So YMC, not having any information, said, yeah, sounds like a good prospect. Let's talk about a joint operating agreement to see if we can come to agreement on costs. They couldn't. Bill Barrett Corporation went silent. And so YMC was somewhat in this purgatory realm, right? We didn't know if electing to participate meant it was consenting, because electing to participate required a joint operating agreement according to Bill Barrett Corporation. And so, but are we now non-consenting? That was YMC's question. And so when the application came through, the notice of hearing, which when you get a notice of hearing as a mineral owner, you don't see the full application or who's listed as non-consenting or consenting owners. YMC was still in purgatory, but at least it knew with the order, okay, we'll get some certainty here. Either we're going to get involuntarily pooled or not, or something's going to happen. So then order 407871 came down. YMC now knew, okay, any unleased owners were deemed non-consenting. That means 3460-116 applies. And so that's our liability, 200% intangible cost from production, or that's our liability. And our monetization is the 12.5% mineral owner royalty that comes from that. It had certainty. It knew its exposure, it knew its monetization, and so therefore it relied on the order. Then they wake up a couple years later, and Bill Barrett Corporation has now sued them. And when they used their defense, we looked and we relied on order 407871, and now they're trying to come back and now change that. And they're trying, Bill Barrett Corporation is trying to change that order in order to get our better position in the civil lawsuit. They're trying to eliminate one of YMC Royalty Company's arguments. And it's not going to work because the order still is what it is as of October 2013. And YMC still relied on it. But the commission should not be amending orders that have been on the books now for almost 4 years that one of the mineral owners has relied on, and now all of a sudden kind of take the rug out from underneath them. And that's really where a lot of YMC Royalties Company's protest comes from. Now, to the bigger issue, the other issue, that's Bill Barrett Corporation's argument about order 407871 not complying with 3460-116, I just strongly disagree. Now, as we've walked through with Ms. Joes, CRS 3460-116 states, as to each non-consenting owner who refuses to agree to bear his proportionate share of the costs, and it goes on, the order shall provide for reimbursement to the consenting owners who pay. So what this statute does is it contemplates two types of consenting owners, those who pay and those who don't, and two types of non-consenting owners, those who pay and those who don't. So if all non-consenting owners refuse to pay and all consenting owners paid, as seems to be kind of the intimation here with what's wrong with order 407871, then these qualifiers in the statute would be superfluous. So it's simply because somebody pays or does not pay or elects to pay or agrees to pay doesn't make them a consenting or a non-consenting owner, because you could be either as both a consenting or a non-consenting owner. So in this case, YMC Royalty Company elected to participate in the drilling of the Greasewood well, but refuses to pay costs. So the question then is whether 3460-116 contemplates an owner who elected to participate but refuses to pay. Now, CRS 3460-116 says nothing about electing to participate. But Rule 530A, the Commission's Rule 530A, gives us this guidance. And what Rule 530A states is that 3460-116 applies to any owner, regardless of if they're consenting or non-consenting. It says any owner who fails or refuses to agree to pay for the cost of the well. Now, what Rule 530A, and that anybody who is that, they're deemed, their mineral estate is now subject to 3460-116. So if there's no agreement, it doesn't matter if they're consenting, electing, non-consenting, put any adverb you want in front of them, it doesn't matter under Rule 530A. What matters is if they have agreed or have failed to pay their costs, which YMC Royalty Company has undisputedly has not paid any costs for this well. And so even under that rule, the Commission goes to 3460-116 as the basis of recovery, meaning that Order 407871 does not need to be amended. It's accounted for. Rule 530 gets us there. If there is no agreement, as contemplated by Rule 530A, And as YMC contends, then pursuant to Rule 530A, CRS 3460-116 applies because YMC has neither agreed to nor paid any of the costs of the Greasewood well. Thus, the order 407-871 is accurate in its current form, and there is no need to eliminate the first sentence of paragraph 4. That sentence deems all unleased owners as non-consenting. As Rule 538 contemplates, any unleased owner is free to change that determination by agreement with Bill Barrett Corporation. YMC did not want to change that status, so they never entered into an agreement with Bill Barrett Corporation. Thus, Order 407-871 accurately reflects that all unleased owners are deemed non-consenting until such owners and Bill Barrett Corporation both desire and do change that status by mutual agreement. There's two other grounds I'd like to briefly hit on before I conclude. The first one is this somewhat of a jurisdiction argument that I've made, and I just want to make sure I'm very clear on this. Order 407-871 came from the commission. So obviously the commission has jurisdiction to amend its own orders. That is not the YMC Royalties Company's argument. What YMC's Royalty Company's argument is that Bill Barrett Corporation has waived and is therefore stopped from now invoking the commission's jurisdiction to change that order that YMC Royalty Company has relied on. Because this is an exact issue we brought to the U.S. District Court for the District of Colorado, that the commission has jurisdiction to determine these costs and to determine if YMC Royalty Company was non-consenting or consenting. How does 3460-116 apply to this? We made that argument, and Bill Barrett Corporation objected successfully and argued that, no, the commission does not have jurisdiction. The U.S. District Court has jurisdiction. And so because they've made that argument, they should be stopped now from trying to change the order 407-871, at least while the lawsuit is pending. Because what they're trying to do here is change the evidence that YMC relied on. So it goes back into a little bit of the equitable estoppel argument, but it's just another inroads into that. If Bill Barrett Corporation wanted the ability to come back to the commission and amend order 407-871, they should have agreed to us that the district court, U.S. District Court, doesn't have jurisdiction then, that we should come here first, make that determination, and go through this process first, which is what YMC Royalty Company said the entire time. And so now that they're kind of trying to have it both ways. And so that's why they should be stopped from invoking the commission's jurisdiction. I very much wholeheartedly agree the commission has jurisdiction to change its own order. It just, should it allow Bill Barrett Corporation to invoke its jurisdiction in this particular case? And the last point I'd like to make is that the requested, I'm not quite sure what Bill Barrett Corporation is asking of the commission. I'm not sure if they're asking to eliminate the first sentence of paragraph 4 under the order part, or if they're asking to substitute that with what's now being promulgated starting in July of 2017 for these kind of involuntary pooling orders. Now, to the extent that Bill Barrett Corporation is just seeking to eliminate that sentence, I want to remind the commission that CRS 3460-118-4E, at least in my opinion, doesn't allow just to strike out that sentence, because that statute requires a provision regarding the costs for owners and the proportion and things like that. And so as it currently stands, 407-871 gets us there because it says, look at 3460-116, that goes through certain owners, certain costs, and so we get that provision. Now, just striking it out, though, we would have no provision for unleased owners. What are their costs, things of that nature. And that's in 3460-118-4E requires such a provision. So I don't think that the commission can, pursuant to 3460-118-4E, just simply strike out the sentence. If anything, the commission would have to substitute that with the current language. Now, the substitution, we still walk into the same equitable estoppel issues. We still walk into it doesn't necessarily comport with 3460-116 because electing to participate is found nowhere in that statute. And so what we would posit, at least with YMC Royalty Company, is that the application should be denied in its current form. And if Bill Barrett Corporation, perhaps after the civil lawsuit is resolved, wants to remake the application, we'll take a look at it then. But as it stands right now, with just the request for eliminating the language, I don't think the commission can go there pursuant to 3460-118-4E. It would have to substitute, and the substitution doesn't resolve YMC Royalty Company's other issues. So in conclusion, the commission cannot amend Order 407-871 as requested by Bill Barrett Corporation. In its current form, the order accurately reflects CRS 3460-116 and Rule 530A. All owners who refuse or fail to agree to pay the costs are subject to 3460-116. And Order 407-871 accurately reflects this by deeming all unleased owners as non-consenting. If an unleased owner desires to change its status, it can do so by agreement with the operator. To the extent the commission disagrees with me, then the commission is stopped from amending Order 407871 some 4 years after it was entered and after YMC relied on it to monetize and to make certain what its exposure to liability is. So for these reasons, YMC Royalty Company humbly and respectfully requested the commission deny Bill Barrett Corporation's application. Thank you.
Commissioners, questions or comments?
Can we have rebuttal, Mr. Chairman?
Pardon?
May we have rebuttal before the questions?
Yeah.
I think that would help clarify things.
Sure.
So let's just go down the list of the obfuscations that we need to dispose of here. 118E doesn't apply here at all. That's state units. It's not applicable to the 116 pooling units. So take that off the table. The reason that we prevailed on the jurisdiction issue is because we brought a breach of contract case. We didn't raise the pooling statute, we didn't raise Rule 530, and we didn't raise the order. That wasn't part of our complaint. They're the ones who brought it in there. So that's why we prevailed on jurisdiction in the court. Some misstatements. Section 116 of the Act does not contemplate either a lease or a JOA. There is no reference to a JOA in the statute. There's no reference to a JOA in Rule 530. And this commission has never, in my 30 years of experience, ever said that a party must execute a JOA in order to be participating in a well. And I think you would probably turn down any operator who said that to the opposite on that. Rule 530B specifically refers to making an election in writing to consent to participate. So what do we have here? Mr. Moorhead said the companies never came to agreement on cost because we didn't do a JOA. Wrong. The JOA doesn't have an agreement on cost. The AFE is the agreement on cost. They executed the AFE. You've got a copy of their execution of the AFE in your packet. So we did have an agreement on cost. We didn't need a JOA to get that agreement. They say they relied on the order. Well, let's go through the timeline here. We sent the election to participate in January of 2013. March of 2013, they send their letter electing to participate, according to that offer letter, execute the AFE, and execute the declaration of pooling. That's everything you need to do under the statute and Rule 530 to be a participating consenting owner in the well, and they were at that point. Then we filed in July the application for the pooling order, and subsequent to that, they execute the division order affirming that they have an 18.75% working interest in the well as a participant in the well. So they agreed coming into the order. They affirmed that after we had applied for the order. That order was issued. It did not identify any non-consenting parties in the exhibit. Even in September of 2014, their letter back to us when they decided they weren't going to pay at all. They never paid a dime on this well. They came and said, well, you know, why don't you just take it out of our share? They didn't refer to the statute. They didn't refer to the order. They didn't say, and make sure you give us our deemed 12.5% landowner royalty while you're doing that. There was no reliance, no reference to the statute, the rule, or the order when they told us we're not going to pay, just take our share out of our revenues here. It wasn't until September of last year that the lawyers for YMC came up with this theory somehow that that first sentence, that incorrect sentence, which misstates the law and which misstates the facts in this case, somehow gave them a reliance argument here. So what we're asking for is take this case back to what it was. It's a simple breach of contract action. The federal judge will decide if executing the election letter, signing the AFE, executing a declaration of pooling, and affirming a division order, whether that constitutes an agreement, a contract under Colorado law. That's not for you to decide. We're not asking you to decide that. What we're saying is don't throw this incorrect statement of the law and the facts into the middle of that so that their lawyers can come up at the last minute and say, hey, we have a new angle on this case. Let's get it out. Let's clean it up. That's what we'd like to see. And I'll reserve any further time we have on that.
Okay. Any questions?
I have about 30 or 40.
Count on the lawyer.
I don't want to monopolize this, so I'll start with a couple and then my fellow commissioners can chime in. So was this form of order that was issued in 2013 the standard form of order that was issued at the time and may even still be?
Yes, at the time in 2013, the order section was the standard language.
I will say it was not in the orders that I applied for. And I made sure that language didn't apply in the orders I applied
Well,
for.
actually, in the application here, the BBC's application, I'm not sure if you were there then.
I believe Mr. Willis was the attorney of record on that.
What's that?
I believe Mr. Willis was the attorney of record on that.
Yeah, he was, from what I looked at. Let's see, the application requested that the order provide that the interests of any owner with whom applicant has been unable to secure a lease or other agreement to participate in the well are pooled by operation of statute and subject to cost recovery provisions. That, I assume you would agree, accurately states or paraphrases what the statute
Yes,
contemplates, correct?
correct. But not what that first sentence of paragraph 4 says.
Right, in the final order. But the application requested a reference to pooling an owner with whom the applicant has been unable to reach an agreement to participate. But that language wasn't in the order. And BBC apparently did not object to the order at the time. The order was issued without that language. So is it fair to say that BBC and YMC assumed at the time that the order accurately reflected the law and the state of affairs?
No. If they'd had me as their counsel, they certainly would have objected.
But BBC didn't object.
Not that I'm aware of.
And BBC's application had requested.
And we had no reason, BBC had no reason to object because they had obtained an agreement to participate.
Well, that's where I was going with this.
Right.
In terms of reliance, I mean, BBC has a reliance argument here too, right? Because BBC assumed, apparently, since all of this is outside the record, all the assertions that both of you are arguing to us, all the submittals that you're giving to us are completely outside our record. We have no way of verifying any of it. To me, it's all irrelevant. So if we assume that what you've told us about the process here, the timeline is true, BBC presumably didn't feel like there was any need to correct the order because they felt like they already had an agreement.
That's correct.
And therefore, I guess I'm going to ask both sides, if you both agree that regardless of the language of the order, if you had an agreement, let's assume that your agreement was enforceable and that you weren't contesting it, that it would not be, you wouldn't be forcibly pooled. The agreement would prevail, correct?
Correct.
I would agree with that too, Commissioner.
So what it seems like to me is that the order had some limited or unfortunate language. It can't override the statute. No one would interpret it to preclude an agreement, whether before the order was issued or after the order was issued. The order could have come out and you could have come to an agreement afterward, and nobody would be sitting here arguing that, no, you can't come to an agreement, you're pooled, that's it, end of story. So the language of the order, I guess I'm asking this as a question, all of that was sort of a rhetorical question, but can the language of the order override the wording of the statute, which it specifically refers to, and the obvious intent of the parties that an agreement would make the order effectively moot?
Well, to the extent that you are or BBC is stopped from challenging that language, perhaps so. And that's an unfortunate result of inaccurate wording in that order. So, and back on your question, whether it's before or after, here we did have agreement before, election letter, AFE, deck of pooling, and an affirmation of that agreement after the order was applied for.
Well, that's your
Well, that's in
position.
your record now. You have all the exhibits. I mean, the exhibits are now in your record.
Right, but it's a legal conclusion whether there was an agreement, whether there was an enforceable agreement. That's what you're fighting about in district court. It's not our jurisdiction to determine whether there was an agreement. So the order at the end of the day, couldn't we just interpret the order? Couldn't we just say here today, we interpret the order to be consistent with the statute and not to preclude an agreement between the parties? Then you'd go to court and you'd fight over whether there was an agreement.
You'd be interpreting language that doesn't say that. I think that would add further confusion. I mean, the first sentence of paragraph 4 is inconsistent with the statute and does not fit the facts. And to say you interpret it as, well, we interpret it otherwise, I think is totally unpersuasive and just confuses things even further.
Okay, so if we change this order, do we have to go back and change hundreds of other pooling orders?
I'm not asking you to do that.
But the legal effect, you would be saying, you're telling us that the order, which was the standard order entered in all pooling situations, was in error.
Yes.
And therefore, that if in fact that was the standard terminology, wouldn't we have to go back or at least open the door to other applicants coming in just like you did and ask for relief depending on the facts of the situation? Wouldn't we be sort of revisiting this every month?
You know, I've been in this business for a long time. I'm unaware of another company is going to come in and say, we signed the election letter, we signed the AFE, we signed the deck of pooling, and we agreed to the division order, but we never had an agreement. I don't think you're going to see that. I think this is a sui generis situation. You will have set the precedent. If it's ever out there again, someone can say, this has been resolved by the commission, and no one's going to try that kind of silliness in front of you again.
I'm not sure that's the precedent. To me, the precedent is you're coming in 4 years later and you're asking us to change an order that was in standard use because of facts, a dispute that has arisen between the parties. And you now say that the order, because one of the parties is trying to use the language of the order, and I'm not commenting on whether I agree that that's a defense that should be recognized. It's not my province. But because of that dispute, you're coming in now and you're asking us 4 years after the fact to change the order because of some external circumstance. So to me, the precedent that you're asking us to set is anybody can come in and ask us to change, correct an order 4 years after the fact or whatever, even though the order itself is subject to the statute.
That's what your order itself says. You retain the right to amend, alter, or repeal.
Right.
So we're simply asking you to do what your own order says you can do.
And you're asking us to do that, even though we all concede that the statute controls and that an agreement between the parties would control. So there's no real need, there's no error, is there?
I think you heard Mr. Moorhead construe the statute differently than you just did and that I have. He's suggesting that first sentence of 4 as it stands is consistent with the statute.
I didn't hear that.
I heard that.
Mr. Lepore, can we get an opinion? I mean, is this number 4 is the first sentence? Is that something we've changed? Because this was wrong? I'd also like to hear from the Attorney General on that as well.
And I think you should obviously hear legal opinion from the Attorney General. But I will say that staff does intend to change the first sentence of paragraph 4 on a go-forward basis. But we do not intend to go back and change prior orders.
I think a fair characterization of the language in paragraph 4 of the 2013 order is that it's imprecise and doesn't exactly reflect what section 116 says. However, I don't think in any way that compels the commission to find in favor of BBC case.
Okay. Commissioners, further questions, comments?
I do have a few questions. So first of all, during rebuttal, I'm sorry, I don't know your name, sir.
1 stolen, 2 stolen.
Okay, whichever one you would like to go by. You said that the commission should take pains and don't throw this incorrect statement of law into our contract case, essentially is what you said, which I find kind of interesting. You filed this application, didn't you?
Yes.
Okay, so the language that was in the order that you're challenging, it seems to me like Ms. Jost is arguing two different things. One is that it's incorrect, it's inconsistent with statute and therefore it needs to be changed. And then is also arguing that there's a second sentence that says the statute's going to win either way, so it doesn't really matter. It's not really that big of a change. And I don't see how both can be true. It seems like if there is a conflict here, the order clearly states that to the extent there is a conflict, the statute will control. And so why on earth would the commission get involved at this late date?
Well, from our standpoint, I guess very respectfully, I would say that's not a conflicting argument. The language is inaccurate, and we are simply asking to have inaccurate language struck from the order. And we do have language in the order that does say the statute trumps, but what I'm saying is we don't really want an inconsistency in the order, whereas the first sentence of paragraph 4 does not accurately reflect the statute. And if left in, it could lead to an inconsistency.
So why did you bring this application?
Well, the other point is that as the agency responsible for implementing that statute, it is your duty in the first instance to properly construe the statute. And to the extent you do that, a court can and should give you deference on that. So it is not at all inconsistent to say this should be your job to clear up the inaccuracy in the first instance.
Okay. So why did you bring this application now?
Because as of September 6 of 2016, the defendants raised that sentence in your order as essentially an affirmative defense in its attempt to evade its responsibilities in our breach of contract action.
And so let's say that we were to agree with you and change that order. Would you then file that amended order in the district court in order to undercut your opponent's claims?
Well, the judge should be aware that that order is no longer relevant to the case. So yes, it would have to be filed with the judge. And the case would then return to what has started, a breach of contract case. And the issue for the court to decide is, do you need a JOA in Colorado to have an agreement to participate in a well pursuant to your statute and your rules?
So you don't think that the language as it existed in 2013, what you're saying is that if the commission retroactively changed the order today, that the language as it existed in 2013 and in the time since then would be suddenly completely immaterial to the case that you have pending in the district court?
The statute, the rule, and the order are all immaterial to Bill Barrett's complaint in district court. If it didn't exist at all, we'd have the same complaint.
So you would have filed this case even if opposing counsel had not raised this issue in the district court case?
Here, the application?
Yes.
No.
It seems pretty clear to me that
No.
the only reason why this application is pending before this commission is because you believe that an order from this commission changing the 2013 order would benefit you in ongoing litigation.
It would clarify the litigation and focus it on what it is, a breach of contract case.
Okay.
I would have had no reason to come here if the defendant had raised it as a quasi-affirmative defense.
If I might follow, I completely agree with where Commissioner Overturf is going here. It seems to me that the exact consequence of our ruling for you would be to involve this commission in your litigation.
Right.
And I respectfully disagree with your statement about it's the commission's responsibility to correct, as you put it, its orders upon application of a litigant who was a party to the proceeding which generated the order, applied based on its interpretation of the statute and didn't object when the order was issued to the language of the order. It's only that a contractual dispute erupted 4 years later. Frankly, it's only that the well apparently was not a good well. If the well was a good well, we wouldn't be here today, right?
More than likely.
You'd be, or maybe you'd be arguing the other way. Maybe you'd say, we never sent you an operating agreement, so you weren't in the well. and you'd be fighting over that. So the well wasn't a good well, so now you don't want to pay, your client doesn't want to pay its share of the cost. You want to enforce the agreement. That's why we have courts. But you're essentially, it seems to me, collaterally attacking an order of this commission, which we all agree is subject to the language of the statute, would be interpreted in a way that we all agree it should be interpreted, which is that an agreement between the parties would I don't want to use the word that starts with a T, would override whatever is in the order. And so it seems to me that that we can all perhaps agree that the order was unfortunately worded, but it wasn't worded in a way that would actually prejudice anybody, except that now you've gotten into a contractual dispute where one party or the other is attempting to say that the order says or means something other than what the statute says it means. That's, to me, what the court ought to resolve.
Well, respectfully, BBC's not dragging you into litigation. You're in the litigation because the defendant has raised your order as part of his case.
We're not in, the commission's not in the litigation.
You will be. I'll have be forced to subpoena someone from the commission to explain the defect in that first, in that paragraph. If the court's going to entertain that affirmative defense in the litigation, yeah, you'll be in that litigation.
You know, that's for you to determine what your procedures are.
But I say, I'm not dragging you in, you're in. They raised the order, they raised the affirmative defense.
This commission is not a party to that litigation, it has no jurisdiction to resolve your dispute.
I'm not asking you to resolve our dispute.
Certainly you are. Absolutely.
No, I'm asking you to correct your order.
No, you're asking us as Commissioner Overturf.
Okay. We're getting off the beaten path here.
I have no further questions.
May I ask one other question? This Exhibit 1 that was circulated by BBC during the rebuttal?
Yes, that was Exhibit 1 that was attached to our pre-hearing statement that was not objected to by YMC.
Okay, thank you.
I guess I'll just make one comment, though. I, for one, don't appreciate this avalanche of extrinsic materials that both of you have submitted. You're asking us to take on faith all kinds of assertions, all kinds of materials that you've submitted in your court proceeding. We have no way of verifying. It's not relevant to our role. And it's an imposition on our time and on our resources. And I personally think that it was improper. And I think the arguments based on those materials, such as estoppel, are improper arguments.
Okay, further comments?
Would you like to close the record at this point, Mr. Chairman?
If there's nothing further.
All right, record's closed then.
Mr. Chairman. Mayor Holton.
Yeah, go ahead. Yes.
Both parties have some time left, Mr. Chairman, so I don't know if you want to allow closing arguments, but we typically do that if they have time left.
It's his fault. He made me do something I didn't want to do. You guys want to make closing statements?
No, sir.
No, sir.
No, sir.
Okay.
Thank you.
Record's closed. Okay. Need a motion and or further discussion.
Okay.
Mr. Hawkins.
First off, I'm going to say I'm not an attorney. So, but I was very persuaded by Commissioner Boygan's comments that this order was issued 4 years ago. None of the parties objected for 4 years. That it rectifies any inconsistency with the statute in itself. I'm happy to not have to make any changes to the order.
Further comments?
If I can just make one comment, I think that this is plainly attempting to enlist the commission in order to give one party in a contractual dispute a leg up in that litigation. And I find that incredibly improper. And I agree that this is a matter that did not need to come before the commission and probably ultimately wasted valuable state resources. One of the things that I'm really curious about is that under the rules, there isn't a specific provision allowing for a particular given amount of time in which a party can request an amendment to an existing order. This idea that somehow you can come back 4, 10, 37, 86 years later and ask for an amendment to an existing order on which people have relied is not only illogical to me, but I would think the regulated community would be particularly outraged at that. I mean, when you talk about having no consistency, no ability to kind of depend on the regulatory decisions that this commission has made, I think it's incredibly problematic. And so one of the things that I would like to talk through is whether there should be, I know there are other state agencies where if you want to reconsider an action of an agency or a commission, you have to file an application seeking reconsideration within 30 days, 20 days, something like that. It seems to me like including something like that in our standard boilerplate language might avoid this type of a situation in the future. But nonetheless, even with the language that we have here, I think the commission should, even if the commission does have the authority as the applicants state to go back and change our order, I don't think we should exercise that authority here. So I would deny the application.
Okay. They can ask, that doesn't mean we have to give.
Yes.
Anything further? Okay, request a motion.
A motion that the application to amend this order, whatever the number is, 407-871 be denied.
Motion by Hawkins.
Second.
Second by Jolly. It would be a motion to deny number 407-871.
I might have then one opportunity to make a quick comment. I don't know whether it would be appropriate as a part of the motion or in the dialogue to have the commission on record that it interprets the order to be consistent with the statute. In its, just that it interprets the order to be consistent with the statute.
Well, I think that's pretty evident at the time they did it, even if they are going to change the language.
Okay, fair enough. Then I withdraw my comment.
I mean, to me, it looks like the whole paragraph is superfluous. I mean, 7 pretty much takes care of all of it. So, okay, we're going to call for a vote. All in favor of denying order 407-871? Say aye.
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 Opposed? Motion carries.
Great. Thank you for your time this afternoon.
Thank you.
Thank you, commissioners.
Okay, if there's nothing further, motion to adjourn.
So moved.
Motion by Hawkins.
Second.
Second. 2 seconds. Okay, all in favor?
Aye.
We are adjourned.